Hey, good morning, everybody. Before we get started, I just wanted to say thank you to all of you. Today is episode 200 of the live show. I can't believe it's been 200 already. But you guys keep showing up. You give me all the love and support, and I just appreciate it and wanted to say thank you so much. So with that having been said, as they say, let's roll, nerds. Once again, good morning, everybody. Welcome to the Courtroom Files Live, episode number 200. Let's start our day with Judge Simpson.
Good morning, Your Honor. Ashley Felton for the people. Your Honor, at this time, people do waive any conflict between this honorable court and the Office of Public Defender. For the record, the people do not believe that any conflict exists. We make a waiver for the avoidance of all doubt.
Thank you.
Assistant Public.
Hey, really?
Lauren did it yesterday, so my turn today. Assistant Public Defender Natalie Pate.
She does it every time.
I know, because she's the main one.
So who made you do it today?
Miss Joy, Miss Gaines, sorry.
I see. I actually knew that because I saw Miss Gaines there and I said, that's why Natalie's doing it.
That is correct. Making sure that everyone knows it. So Dennis taking notes. I mean, Mr. Denway. So
On how to do it, it's like 20 words. I know. Okay, go ahead.
I'll turn it into like 30. Assistant Public Defender Natalie Pate with and on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would waive such a conflict.
Thank you. And the court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Kenyon Jackson.
Ashley Felton for the people.
He's on hold. Apologies, Your Honor.
No, it's okay. I saw your name and I'm like, okay, whatever.
J. Grant Miller, P58658 on behalf of Mr. Jackson. It was a late appointment. I haven't even spoken to him at Macomb County yet.
Yes, he's there. Can you state your name?
Kenyon Jackson.
Thank you. All right. So it was a late appointment and you're looking for an adjournment.
Yes, Your Honor. I'd like to get the discovery and discuss it with Mr. Jackson.
All right. Mr. Jackson, I'm going to adjourn your probable cause conference in your two cases. I'm going to adjourn them to January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
And we'll continue. Thank you.
Michael, thank you for the gifted membership. Great way to start out the day, and I surely appreciate it. Thank you so much.
Case of the people versus Rahamio Smith.
Ashley Felton for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Smith, who is via Zoom at the Forensic Center. Sir, can you please state your name for the court?
I'd like to say I'm sorry about all the confusion I'll cause or all the mishap belongings or I don't know what to say. I'm just trying to say I'm sorry about any I saw a mishap. I'm sorry, I wasn't in my right mind. And I'm doing better with the help of the
Thank you. That's close enough.
Mr. Smith.
Go ahead.
Your Honor, is Your Honor in receipt of the 90-day progress report for the Forensic Center dated November 25th of this year?
I am.
Thank you. Sorry, Sorry.
report indicates that the defendant remains incompetent to stand trial at this time.
Yes,
Is there any other additional evidence?
nothing from the defense, Your Honor.
Anything else in the people?
I'm so sorry, Your Honor. I have nothing other than the report that's been submitted about this report.
All right. And I don't think our time period has passed.
No,
they
Your
do-
Honor.
They do apply a substantial likelihood that he will attain competency.
They do. So I'll need an order, but I'll set a competency review hearing. Is it February 26, 2026?
Thank you, Your Honor.
Sir, very nice meeting in trial, sir. It's too much space in between these court dates. I'm losing a lot of things, you know, in between. I'm losing a lot of things, family and everything. So you can just make this, huh?
I understand,
All right,
Mr.
thank-
Smith. We'll be in touch, okay? Oh, sorry.
All right, bye.
Thank you,
Good.
Your
Thank you.
Honor.
Bond will continue. Court does call the case, People versus James Cobb. Or Cobb. Yeah, Cobb.
Good morning, Your Honor. Kerma Dadush, Mr. Cobbs is approaching. Good to be back.
Good morning, sir. What's your name?
James Cobbs.
Okay.
Your Honor, we don't have discovery on this case yet. We'd be asking to adjourn. I believe this is the first PCC on this.
It is. That objection, probable cause will be. Can't hear over it, Dave. What'd you say? I can't hear over. Okay, who are you? Oh, never mind. January 8th, 2026. Where's Anna Blevins? 9 a.m. Bound continue.
Barbara, thank you for the gifted membership. Again, very much appreciated.
No? Okay. We'll work it out. Court calls the case, People versus Perry Malone.
Ashley Phelps for the people.
Good morning, Christina Saxon for Perry Malone.
Good morning. Mr. Malone, can you state your name, please?
Perry Malone.
Thank you. What are we doing on this?
Your Honor, I'm asking for an adjournment. Ms. Feltus said they're still trying to get the discovery that I requested.
Okay, so we're trying to work on discovery issues.
We are, Your Honor. Thank you.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank
Thank
you.
you. Court calls case of the People versus Joseph Bonville.
Good morning, Your Honor. Christina Saxon for Joseph Pondville, who's approaching.
Your name, sir?
Joseph Fonville.
Thank you. Okay, what are we doing?
Your Honor, I'm asking for an adjournment as I'm awaiting discovery. I was just pointed to this on Thursday.
During this matter to January 8th, 2026, 9 a.m. Bond continue. All right, thank you.
Your Honor, may I make a,
I'm sorry?
I was asking for, to make a bond argument, but. see-
Oh, okay, he needs to come back up then. Go ahead, briefly.
Your Honor, Mr. Fonville is in jail on retail fraud. From the written discovery that I have, there seems to be some confusion as to whether it was him or not. And I'm asking for a nominal bond on being that it was a non-assaultive offense.
People would object. The confusion around whether it's him or not was because he's allegedly been using his brother's name while he was committing this string of retail frauds. There is an additional retail fraud charge that I am reviewing right now. In fact, I was just given the video for that moments ago that I'll be reviewing. It looks like him and another brother of his continually go in and out of different stores in the area and steal whatever they want. Mr. Fonville has an incredibly long criminal history with dozens of retail frauds dating back decades, in addition to long stints in prison for other theft crimes. He's held on a multitude, at least he was held on a multitude of cases. I don't have ex-jail, so I can't make that representation accurately at this moment, but the people would object.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case. People versus Dion Baldwin.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Where are they? Oh, he's coming out.
And good morning, Your Honor. Assistant Public Defender Ben Dunaway on behalf of Mr. Baldwin, who stands to my right.
Your name, sir?
Mr. Dion Baldwin.
All right. You're seeking a forensic evaluation? Or,
Yes, Your Honor.
If I may.
well, hold on a second. Actually, did you get a report?
No, I submitted the referral form to the clerk of the court by email yesterday. He's not yet been.
Order for an evaluation. Right, I see that. Okay, I'm sorry. Got it. All right.
If I may speak, Judge.
You wanted to say something? What do you want to say?
Yes, I wanted to relieve my public defender yesterday when he came to visit me. He just was incoherent with what I was saying. I wanted to proceed with a preliminary examination with 3 people to show for their side: Nicole Jones, Robert Jones, and Booker T. Jones.
What do you mean he was incoherent? You couldn't understand him?
Yeah, he didn't seem to be understanding what I was saying. He was
Oh,
asking me if I was the owner of the home. I was telling him no. I was applying for personal rep of the property.
so he was asking you whether or not you had ownership in the home on a home invasion case.
Yes.
What a shock.
My brother was the last to have ownership.
So
And that
it's not really in your interest to discuss any facts of the case with the judge, whether you like me or not. It's not good for you to tell him the facts. It's best for you to be quiet, Mr. Baldwin.
So the 11/6 was the date
So, sir,
of the last rep. Now
that involves a probate proceeding, right?
yeah, so I
And
have
that's why
63.
your attorney was doing the proper thing, just based upon what you're saying, and asking regarding certain things regarding that. I don't need to know the terms of that, but that's just a natural kind of thing. And sometimes, if people don't really know what the probate issue is, it's hard to explain, which may have, and you probably were doing it improperly and not with the proper terms, which is probably why counsel may not have understood exactly what you were saying. It has nothing to do with him. So your motion to try to relieve the public defender's office, if that's your reason, is denied.
No problem.
And I will order the competency evaluation, and I'll set that for March 26, 2026, 9 a.m. Bond continued. Thank you.
Thank you.
Good morning once again, everybody. Welcome to the Courtroom Files Live, episode 200 today. Again, thank you so much for all of your support. I can't believe we made it this far, but we're not stopping. We're going to keep going. Special good morning to those of you watching over on Kick, our newest platform. Had an interaction there already today with Simply Kaylee, so thanks for joining us. Real quick, before we move on, yesterday we talked about this rabbit that we found outside and adopted. Well, it's home with us now. There's a photo on the screen. It is a boy. We've figured that out. And it is named Epizon, which is Greek for survivor. So we thought that fit. We'll call him Epi for short. And he'll spend the next couple of days getting adjusted to his new digs up with Graham at TCF. So thank you again yesterday for everybody for your support. Again, all of the super chats and everything we got yesterday will go to the initial care for this bunny. And if there's anything left, it'll be donated to the Humane Society. So again, thank you so much. Let's get back to Judge.
I'll recall your case. He just dropped off our screen. Okay. Thank you, ma'am. Court does call the case of the people versus Mary Barney.
Now, is that on behalf of the people?
The public defender Natalie Pate with and on behalf of Ms. Barney, who stands to my right. Please state your name.
Wahoo, thank you for
Mary
giving
Barney.
ownership.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I am requesting an adjournment of both files. I do have a correction to what I wrote in the green sheet, which was correct at the time. Our office has now received discovery in the second case late yesterday afternoon. That being said, we are still requesting an adjournment in order to review it and discuss it with Ms. Barney. Then I do have a very brief request as to bond when appropriate.
Probable cause conference, January 8, 2026, 9 a.m. Esteban.
Thank you, Your Honor. I did speak to Ms. Zenda regarding this, and I do understand that this request was made at the last court hearing regarding this case. We are requesting that Ms. Barney be released to inpatient substance treatment. The only thing that has changed since this request has been made at the last hearing is that Ms. Barney has now been arraigned on the companion case, and it is my understanding that she is now arraigned and there are no new cases coming, so to speak. Outside of that, Your Honor, I'm just asking if Ms. Barney could be allowed to be released to inpatient treatment.
Response.
Your Honor, I'm gonna object again. The reason I say agree, I just don't think that's inappropriate. At this time, for Ms. Barney, I have concerns about the community. I have concerns about the victims. We've talked with them. They are on board. They're really afraid of Ms. Barney and this escalation, her behavior with violence towards them, and their child that was in the home. So I'm just gonna object for the reasons I previously stated, at this time.
And the court's going to continue its order. I'm going to deny the request. Her bond will continue. Thank you.
Understood, Your Honor. Thank you.
Court calls case People versus Michaela Whitfield.
Ashley Feltus for the people.
Good morning, Your Honor. May I please support Todd Kaluzny on behalf of Ms. Whitfield?
Ms. Whitfield, can you state your name, please?
Michaela Whitfield, Your Honor.
Thank you. All right, what are we doing?
Your Honor, we had a probable cause conference on December 11th. We adjourned to today's date for discovery. There's some outstanding videos that I still don't have. I talked to Ms. Feltus yesterday, and she is still looking into getting those videos for me. So we're asking for another probable cause conference.
That's correct. I have reached out to the Michigan State Police. We're looking for a video from an interview room at the post, in addition to one other trooper's videos. We have several videos. We're just looking for a couple more.
Got it. Okay, you think you can get that to them? And if I set this for the 15th,
I hope so, Your Honor.
All right. Probable cause conference will be adjourned January 15th, 2026, 9 a.m.
Thank you, Your Honor.
All right, bond will continue. Thank you.
Thank you.
Thank you, Ms. Whitfield.
Thank you.
Court calls the case People versus Kurt Bushland.
Ashley Feltus for the people.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Bushline, who approaches the podium.
Kurt James Bushline.
All right, you're seeking another adjournment.
Your Honor, we're trying to contact Gratiot County, and I'm just having a little more difficulty than I thought I would. So if we could possibly put it over to the 15th, we're trying to get a universal kind of settlement.
You want the 15th?
Please.
All right. That objection, probable cause conference, January 15th, 2026, 9 a.m. Bond.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Dylan Marshall.
Ashley Feltus for the people.
Good morning, Your Honor. John Dackmack appearing on behalf of Mr. Dylan Marshall. We consent to these virtual proceedings. Mr. Marshall is in the state of New York at this time.
All right. Mr. Marshall, can you state your name, please?
Yes, Your Honor. Dylan Marshall.
Thank you, sir. All right, what are we doing?
Your Honor, the government has offered us a plea resolution. We've accepted that. Your Honor should have written copies of those. We're ready to proceed with the plea hearing.
Plea agreement in front of me without a blue tag. Just saying. That indicates that the defendant will be pleading guilty to an added count 2 of larceny, 200 to 1,000. That the 1-year offense, upon a successful plea to that charge, count 1 would be dismissed. There's a sentence agreement of under 771.1 treatment, whereupon if successful, term of not more than 12 months of compliance, the case would be dismissed. I see. All right. That's the court's full understanding of the agreement.
Yes, Your Honor.
Is that correct, Counsel?
Yes, Your Honor.
All Mr. Marshall, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Again, state your name for the record, sir.
Dylan Marshall.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that becomes the maximum fine. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo or her successor in the 15th District Court. You understand that?
I do.
All right. And understanding all of that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form or had one caused it to be signed on your behalf. Is that correct, sir?
I believe so, yes.
All right. You recall signing a form of advice of rights?
I do.
All right. Do you have any question regarding any of those rights?
I do not.
And you understand that by pleading guilty, you'll be waiving or giving up those rights?
I do.
You understand you're giving up your right to appeal of right?
I do.
Are you on probation or parole?
For this, yes. For anything else, no.
Mr. Marshall, you're not on probation yet. Are you on probation or parole right now for any other offense?
I am not.
Sorry, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty of this offense?
I do.
On September 9th, 2024, at the location of 1200 South State Street, City of Ann Arbor, Washington County, State of Michigan, what did you do that makes you think that you're guilty?
I stole a Michigan football helmet and a national championship baseball hat.
All right. And that was from Schembechler Hall?
It was.
All right. And you had no property interest. Those items that you took didn't belong to you. Is that correct?
That is correct.
And you didn't have anybody's permission to take that property, did you?
I did not.
Do you believe that the value of the property that you took was in excess of $200?
Yes.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would, first of all, not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule? Would it be proper to accept this defendant?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
January 20th at 9 a.m. before Judge Valvo.
January 20th, 2026, 9 a.m. Scheduled before Judge Valvo or her successor. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
It's the Courtroom Files live on a Tuesday? I lose track of time. Yeah, it's a Tuesday, episode 200. Welcome, everybody. Let's change it up. We'll go down to Florida. Say good morning to Wade Mercer.
Mr. Young and Mr. Boutwell, I'm seeing you at the same time because your cases are essentially identical for first appearance purposes. Each of you are charged with violating the terms of your state probation or community control. And in each case, the circuit judge has signed a no bond warrant. What we're going to do today is get you arraigned. And what that means is I'm going to appoint an attorney to represent you if you would like to have one appointed so we can get your case moving. Mr. Young, would you like to have an attorney appointed to represent you? Yes, sir. Great. Mr. Boutwell, same question.
Yes, sir.
All right, I'm going to appoint the Public Defender's Office of the 14th Circuit, represent both of you. Listen to Mr. McDaniel, and then we'll see if you have any questions. Mr. McDaniel?
Your Honor, we're going to plead not guilty as to set this in the January 8th pretrial docket and advise some, Mr. Green to come by and talk to them prior to that hearing.
January 8th. Mr. Mitchell, anything?
No, Your Honor.
Okay, so Mr. Green will see you before your court date. Mr. Young, do you have any questions?
No, sir.
All right, sir. Wish you the best. Mr. Boutwell, any questions?
No, sir.
Wish you the best, sir. Next case we have is Kim Benson. Mr. Benson, good morning. Mr. Benson, you're here for first appearance, accused of one count of grand theft between $750 and $5,000. Mr. Benson, I know that you're on bond, but I believe this allegedly occurred before you were on bond.
Correct.
I think this.
I'm not sure though. Let me double check that, Mr. Mitchell.
I think from what I saw, I thought it happened after.
Well, this says November 28th. Let's see when it was put on bond in the other case.
It was in October from what I saw.
Oh, really? Okay.
Yeah.
Then that's.
No, sir. December. No, sir. December.
Oh, okay.
Yeah, it was after.
I think the original incident may have happened in October, where he was put on bond at the beginning of this month.
Okay. All right, so he was not on bond when this happened. That would be 25-551C if it's the other case. That's one involving Lowe's. These cases today all involve Walmart, and it looks like the bond was posted on about December 5th. There's a misdemeanor too. Let me see if that misdemeanor's one he was arrested on or not. 25-583 That may just be a walk-in. Nope, that was a bond, same day. Okay, so Mr. Benson, the good news is that it does not revoke your bond because this allegedly occurred before you were even on bond. The bad news is, obviously, I'm going to consider all those other cases as part of your bond today. I'm going to see if the attorneys have any additional information, and then I'm going to set your bond in these cases here, the case here, because I think you're entitled to one. Mr. McDaniel, anything on behalf of Mr. Benson?
Nothing except the same stuff as last time.
And it looks like Judge Goodman first appeared him last time, so it must have been a weekend when he got that bond set. So, Mr. Benson, you're going to get a little higher bond today. It's just a different judge, different way of viewing things. Plus, I have additional information of additional charges that judge did not have at that time. Mr. Mitchell?
Your Honor, I think he may have, I'm checking CCIS right now. I think he picked up a new charge in Leon County after these original cases happened.
All right. So, Mr. Benson, give us a second look at that. Go ahead, Mr. Mitchell, and check it out if you
A
will.
bond in which, yeah, there's case number 253302 CF out of Leon, larceny obtained mail by fraud, deception, burglary of structure. He just posted a bond yesterday, and I think that's why he's here before us today.
Do you have the complaint to see when that allegedly occurred?
Yes, let me pull that up. At approximately 5:18 a.m. on December 5th, patrol officers responded to a call of two people trying to break into mailboxes nearby.
5:18 a.m. on December 5th, wasn't that when he posted bond in Jackson County?
I think so.
Sarge, what do you show him posting bond in Jackson County? What date?
December 2nd. December 2nd.
December 2nd?
3rd, I'm sorry, December 3rd. is the
Okay,
date.
so he allegedly posted bond, or he posted bond on the 3rd, then he got arrested in Leon County for a crime allegedly occurring on December 5th.
Yes. This is.
All right, so let me read that complaint. It appears the judge has already found probable cause, but I want to read the complaint anyway because there's a good chance I'm fixing to revoke your bond in Jackson County, but let's read the complaint first.
That's what I wanted to pray.
Is this the right thing? Mr. McDaniel, I'm not gonna ask you to say anything that's gonna hurt your client, but if there's anything you say that may help him, and I'd glad to listen about the date.
I don't know anything about that, so I know he said he got out on the 4th and he's, I think I'm gonna let him be careful what he says, but whatever he wants to say, I'm gonna let him say it. But, I think he said maybe he was in the wrong place, wrong time, but, but go ahead, Mr. Simpson.
Yeah, I was saying I got out on the 4th and approximately maybe like 8, the person that come pick me up, they was wanted in Leon County. They had 3 priors, and because of the charges that they were wanted for, they kind of swept me up because I was with the person, not that I so much committed it. So I basically it's the wrong, it's the wrong time.
So you did get charged in Leon County, correct?
Yes, sir.
And you posted bond over there? You
Yes, sir.
posted bond over there?
Yes, sir.
Let me finish reading the complaint. Yeah. The 3 of them went, according to Benson, according to what the police officers say, you told them, the 3 of them went to the north side of Tallahassee per Cody's instructions. That's the other person. Due to Cody saying she had coupons to drop off, Benson admitted to driving through the neighborhood where Cody would reach in the mailboxes and place the coupon into the box. Cody would sometimes grab mail in the boxes as well as place the mail inside the vehicle. Benson claimed not to know what Cody was doing with the mail and that he was only driving. Benson could not say if Peterson had ever grabbed any mail. I eventually asked Benson about my case. Benson admitted to previously driving Cody to other areas of Tallahassee. That's more than enough there to revoke your bond. I'm revoking your bond in the Jackson County case. So it's going to get confusing because you're entitled to a bond in today's case. That bond in today's case is going to be $25,000 cash or surety. Don't try to post it because I'm revoking the bond that you were on, that you posted a couple of days before you, according to this complaint, you admitted going to Tallahassee and driving someone through a neighborhood while they took mail out of a mailbox. That's items were allegedly used later for some type of theft, or they've been prior thefts used in similar circumstances. So don't try to post a bond, Mr. Benson. I'm revoking your Jackson County bond. Mr. Mitchell, if you give me an order to that effect,
Okay.
I'd appreciate it.
Is it-
You're also going to get a notice for your court date, which will be December 6th in Jackson County at 8:30, but you're going to be in custody, so you'll be seeing the judge on that day. Mr. Mitchell, question?
January 6th.
January 6th. I apologize. January 6th, Mr.
Is
Mitchell.
that for both cases, the felony and the misdemeanor?
Yes.
Okay.
Because both of them were on bond December. The bond was filed with the clerk December 5th, but he was posted like December 2nd or
I
3rd.
gotcha.
But it wasn't filed with the clerk till the 5th. That's when the bondsman got it there. The jail got it to the clerk's office. So, Mr. Benson, don't try to post bond right now. There's certainly sufficient evidence that you've committed a new crime after you were on bond, so you're not going anywhere, at least for the time being, sir. Any questions?
$25,000.
He was originally on that arraignment docket for the 5th. I think we can move into the jail docket, given that. Okay.
Mr. Mitchell, I didn't see that new charge.
I just caught it today too. I was looking on there, see if there was something else.
Thank you, Your Honor.
All right, wish you the best, sir. Next case is Kimberly Broxton. Broxton, good morning. Ms. Broxton, you're here for first appearance, bless you. You've been accused of 1 count of possession of methamphetamine, possession of drug paraphernalia, a driving license suspended, and the 4th charge is smuggling contraband into a prison or jail. Ms. Broxton, there is probable cause for these charges. I looked at your criminal history, ma'am. I know that you got out of prison, I think, in 24. I think you're entitled to a bond as far as I can tell. Ms. Broxton, I do have a question. The jail sheet says that you are currently on probation. I don't want to, normally I'm going to increase the bond for someone that's on probation, but I can't find that. I don't know if that's accurate or not.
I'm not on probation.
Okay, I did. It's okay. That helps. That's going to get you a regular bond instead of an enhanced bond. So I wanted to make sure. So thank you for letting me know that. I'm going to listen to the attorneys and see if they have any additional information before I decide what bond to set. Mr. McDaniel, anything on Ms. Broxton's behalf?
Nothing, Your Honor.
Mr. Mitchell?
We just request random UAs.
So Ms. Broxton, since you're not on probation, you're going to get the normal bond for individuals that don't get a conditional release, and you're not going to get a conditional release with your history. The methamphetamine is a felony charge, and the contraband are felony charge too. Both those are felonies. So they're going to have a $5,000 bond each. The other two charges are misdemeanors, paraphernalia, and driving while license suspended. They'll have a $2,500 bond each. When you add those four together, you get a total bond of $15,000. Ms. Broxton, that's cash or surety, ma'am, and you've got a condition of random urinalysis. That means that you very well may be drug tested, and if you test positive for something you don't have a legal prescription for, ma'am, that could violate your bond. So you'll get a chance to use the phone in a few minutes, Ms. Broxton. If you post the bond, you'll be released. Ma'am, if you're not able to post the bond, then what's going to happen is the public defender's office is going to see you at the jail. You will be on the January 6th arraignment docket to see Judge Garcia, and we'll see if the state has made a charging decision by that point. Ms. Broxton, do you have any questions?
I just had the drugs that were in.
You have questions about the bond? Nothing else, Your Honor.
Okay, thank you.
All right, ma'am, wish you the best. Next case is Russell Phillips. Mr. Phillips, good morning. Mr. Phillips, you've been here accused of one count of possession of methamphetamine, one count of possession of marijuana less than 20 grams, and one count of possession of drug paraphernalia. I've read the complaint. In your case, there does appear to be probable cause for those three charges. And I've also looked at your criminal history, Mr. Phillips. As far as I can tell, you're entitled to a bond. Let me make sure the attorneys don't have any additional information before I set that bond. Mr. McDaniel, anything on behalf of Mr. Phillips?
No, Your Honor.
Mr. Mitchell?
The same condition of random UAs.
Mr. Phillips, I'm going to set you the same bond I would set for Ms. Broxton and the other individuals that got some criminal history but not on probation. Sir, your methamphetamine charge will be $2,500. Excuse me, the methamphetamine is a felony. It'd be $5,000. The other two charges are misdemeanors. There'll be a $2,500 bond each. Mr. Phillips, your total bond is $10,000 cash or surety. You do have a condition of random urinalysis on that bond, which means, sir, that you could be drug tested at any time. So be aware of that possibility. Mr. Phillips, you'll get to use the phone in a few minutes, sir, to try to post the bond. If you post it, you're out of there immediately. If you're not able to post it, then the public defender's office will be in contact with you. Your court date will be January 6th at 8:30 a.m. Central Time. Mr. Phillips, do you have any questions?
No, sir.
All right, sir. I wish you the best. I believe the last case we have this morning is Gregory McIntosh. Mr. McIntosh, good morning, sir. Mr. McIntosh, you're here because you've been accused of one count of driving under the influence. Mr. McIntosh, there is probable cause for the charge. When I looked at your driving record, sir, it appears that this may actually be a felony charge. It appears you have 3 prior DUIs. Now, having said that, I think the most recent one is about 20 years ago, and the other 2 are even older than that. So I think you're entitled to a bond. Those are obviously factors for me to consider. So let me see if the attorneys have any additional information before I set you a bond today. Mr. McDaniel, anything?
Nothing else, Your Honor.
Mr. Mitchell?
We just request that as a condition of his bond that he not possess or consume any alcoholic beverages.
Mr. McIntosh, I'm going to set your bond at $5,000 cash or surety because it appears you technically qualify for a felony charge. You have a condition of no alcohol. As part of that bond, you can't possess or consume alcohol.
Yes, sir.
And based upon the breathalyzer, you're also going to have a condition not to drive a motor vehicle. Now, Mr. McIntosh, if you can get a work permit, you can come back to court and I'll consider that, or Judge Garcia will consider it if this goes to felony court. But right now, no driving because this appears to be your 4th DUI, even though the others are older, and we'll see what the state's going to do. So it's going to get complicated. So let me try to explain. Mr. Mitchell's office has to make a decision. When they look at your driving record and your criminal history, they either got to send it to felony court and charge it with felony DUI, or Mr. Mitchell may decide to leave it in misdemeanor court. That'll be his decision. The court date I'm about to give you is if it stays in misdemeanor court. If it goes to felony court, this court date will change. But right now, the officer's charged you with a misdemeanor. So I'm going to ask the jail to give you a notice for the misdemeanor case date, which will be January 5th.
I think
February.
We're already past the cutoff. Okay.
Yeah.
So, wow, that's going to be really confusing. I'm not going to give you a court date today. Mr. Mitchell, is it too early? I'm assuming it's too early for y'all to know which way you're going to go without looking at the full criminal history.
Yeah, we got to look at the full criminal history.
I'm not going to give you a court date because I don't want you to get confused. You're going to get a notice in the mail to make sure that we're going to check your address in just a second. Make sure you show up at court on whatever date you get the notice in. I'm afraid if I give you a court date in February and then they do take it to felony court, you get a court date in January, it's just going to be confusing. So, Mr. McIntosh, we've got a 7546 address out of Sneed's.
Yes, sir.
I'm not going to put your full address on the record, but is that the right numbers?
Yes, sir.
Okay, so make sure you stay up with your mail. It's probably going to be February it's probably going to be February 2nd, but it could be February 3rd, depending on what the state decides. You will get to use the phone in a few minutes, sir, to try to post the bond. And if you post the bond, you'll be released. Just remember, Mr. McIntosh, no alcohol and no driving. If you get your driving license straightened out, come back to court and you can request we'll see what they give you. If they give you a work permit, obviously I'll consider that. I don't think they're going to give you a work permit on the 4th DUI. That's why I'm saying no driving at all based upon the breathalyzer. Mr. McIntosh, do you have any questions?
No, sir.
All right, sir. I wish you the best. Mr. McDaniel, that's everything I had on my list. Anything else from the public?
Okay, as they wrap up, because I think I forgot to say it earlier, thank you, Barbara, for the 5. I appreciate that. Programming note, starting January 5th, we are adding a 4th hour to this show, and as a result, we'll be starting an hour earlier. So again, starting January 5th, you'll be seeing us at 9 a.m. Eastern, 6 a.m. Pacific, so bear that in mind. Let's do something different, because why not? It's episode 200. Let's go to DeKalb County, Georgia. This is Judge Mike Jacobs, who I don't believe we visited with before.
Sounds good. Barahona Rodales?
He's also a Spanish speaker. I have an offer on this. I still need to talk to his felony attorney, so maybe 2 weeks, Judge, would allow me time for them to get back to me.
Okay, that'll be a 2-week bring back on Barahona Rodales. And then I've got Aaron Brooks.
State has consented to a UJR in this case, Judge.
All right, I will sign it. Right, who is in the courtroom? It looks like Mr. Weldon, but he's pretty far away, so I don't
Yes,
know.
sir.
I can't, Mr. Weldon, they need to unmute in the courtroom. I'm sure there's going to be some horrible echo. I can hear you, yeah. All right, you consent to a UJR here, yes?
Yes, Your Honor.
Sounds good. All right. Janarthra Burton?
I sent along contact information, Judge, would request that you lift this bench warrant. It looks like a misarrangement.
Okay, yeah, that's fine. That's going to be February 25th arraignment at 1:30 p.m. February 25th arraignment, 1:30 p.m. for Janarthra Burton, and I will recall the bench warrant. Courtroom 3C of the DeKalb County Courthouse. Anthony Carter, 1, 2, 3 cases.
Judge, the only case where there's going to be any action is position number 8. The state has consented to an $100 cash bond. He was no bond status on that one, so I will be sending along a bond order for your honor shortly.
Okay. 1, 2, 3. All right. Hold on. Dontavius Cody.
He looks like they just logged on, Judge. I would still need to talk to him. The rest of the calendar may go pretty quickly because it's just bonds. So if your honor wants to wait and see if we have time. But at this point, I'd need to speak to him about the state's offer before we go forward with it.
He just logged on from where?
I believe he's at our YDC, Judge.
That's correct.
Oh, okay. Well, I mean, if you want to talk with him, we can do that. Where is he?
Edward Jaw looks like.
Yeah, got it. Okay.
Hi, hello, I'm Miss Edwards. I'm the juvenile detention counselor here with Cody.
Okay, sounds good.
Should be quick, Judge.
Put Ms. King and the Edward Jaw rectangle in a breakout room. There you go.
While this team talking to the defendant, the state's going to pull the accusation on Odyssey and sign that and send it to Ms. Jones in case he wants to plea.
Okay, sounds good. That was you talking to me, Mr. Weldon?
Yes, Your Honor.
Okay, all right. How you doing today?
Oh, I'm good. 2 days before Christmas, Your Honor. It's good to be here.
Yeah. Okay. Well, good to see you, sir.
Thank you. Likewise, Judge.
And happy holidays.
Happy holidays.
I mean, while we're waiting, we could maybe do the FTA calendar. That only goes on for 4 pages. Well, where it says bench warrant not signed, I in fact signed these bench warrants last night, so they're going to need to be fished out. But let me go ahead and call the FTA calendar while we're waiting. All right, William Brooks, are you here? William Brooks. I'm not going to, by the way, I'm not recalling the bench this calendar after I call it.
Yes, sir, I'm here. Yes, sir, I'm here.
So if you are not here right now, it's not aimed at you anymore, Mr. Brooks, but if you are not here right now and you don't unmute when I call your name, you have missed your opportunity.
Can you hear me now, sir?
Yeah, I can hear you, Mr. Brooks. You're fine.
Okay.
Okay. So I'm going to set your case. All of these court dates are going to be in courtroom 3C of the DeKalb County Courthouse. But you, Mr. Brooks, are going to be set for February 25th arraignment at 1:30 p.m. And I will recall your, well, I've signed it, so it needs to be fished out of the stack. All right. February 25th arraignment at 1:30 p.m. For Mr. Brooks.
Okay.
And we will make sure you don't have a bench warrant.
Okay, thank you, sir. I appreciate you guys.
No problem. So we'll see you at 1:30 p.m. February 25th.
Okay.
Kennedy Fleming. Respond when I call you, please. Kennedy Fleming. All right, that bench warrant will stay in FTA status and it needs to be entered. It's in that stack. Charles Harris.
Hey, Your Honor.
All right, you, all right, you've only had one bench warrant. I'm going to set your case for February 25th arraignment at 1:30 p.m. in courtroom 3C of the DeKalb County Courthouse, and I will recall your bench warrant.
Yes, sir. Thank you.
All right, you're all set. Gita Hawkins. Gita Hawkins.
Yes.
February 25th arraignment at 1:30 p.m. in courtroom 3C of the DeKalb County Courthouse, and I will recall your bench warrant, ma'am, okay?
Okay.
All right, you're all set. Derrickis Johnson, or Derrickis Johnson, Derrickis Johnson, sorry. Derrickis Johnson. That one will stay in FTA status. Neon Cower Karlar. Neon Cower Karlar. That one will stay in FTA status.
Yes, Your Honor, I'm here.
Oh, okay. I'm going to recall your bench warrant, sir. You're going to February 25th arraignment at 1:30 p.m. February 25th arraignment, 1:30 p.m. Okay.
All right, Your Honor.
All right. Quentin Tierra Martin. Quentin Tierra Martin. All right, this one has a bench warrant in the stack and it needs to stay in FTA status. This is her second bench warrant in this case anyway. So Quinn Tierra Martin. The $5,900 bond. And this is a second bench warrant in the same case. I doubt it was going to get recalled anyway. But it needs to stay in bench warrant. This bench warrant needs to be entered, Donita. Demetrius Massey.
Here.
You've only had one bench warrant. You missed calendar call. I'm going to set you for February 26th calendar call at 9:30 a.m.
I've already done probation for this charge. I've already done probation.
I don't believe that's correct.
Yes, it is.
No, ma'am, don't. If you want your bench,
3 charges.
Ma'am, you're still going to have to come into court to address it.
Okay, what day? I'm sorry. I apologize. What day?
Hold on. Let me just. Yeah, it's still an open pending bench warrant.
So. Well, I already did a year probation. It was 3 charges.
Ma'am, I don't know what to tell you.
That one was included. I know. I understand.
Don't. Let's not argue about the status of your case. I'm telling you, I have a pending case. I need to address it, and I need you in court to do so. And you have a bench warrant, which I believe you want to get recalled today. Let's just do that, okay? And that's going to be February 26th calendar call at 9:30 a.m. February 26th calendar call at 9:30 a.m. We will see you there. But from my standpoint, you do still have a pending case. Might have been a different case. I don't know. Might have been something you did preliminary. No, ma'am, I got it. But so one of the new announcements that I do in court is that, like, I only know about your case what I see on the docket, and the rest of it is you talking with the state or your attorney. I know you had an attorney who did withdraw on the case, just saw that order on the docket. But in any event, most other things happen without my involvement. So you're going to need to come into court. If you think you've resolved your case, then you need to talk with someone who's not me in court. You need to, let me say that one more time. If you think you resolved your case, then you need to talk with someone who's not me in court.
Who would I need to speak with?
I'm going to go over all that with you in court. Okay? That's how all that works. So, hold on one moment.
Well, we're holding on one moment. Thank you, Ashley, for all of the research on this. New judge.
All right. Anyway, so bottom line is you're going to need to talk with someone. Like I said, you had an attorney, your attorney withdrew. If you think you resolved your case, you might need to talk with my staff. You might need to talk with, if you think you finished your probation, you might need to talk with a probation officer. Maybe you need to talk with the state if you have a pending case. But all that happens in court. It doesn't happen by you just kind of interrupting me on a Zoom call. It just doesn't ever work that way. So, so we're going to do February 26th calendar call at 9:30 a.m. Okay.
Thank you, Your Honor.
All right. No problem. Thank you. February 26th calendar call, 9:30 a.m. courtroom 3C of the DeKalb County Courthouse. Just about anyone you might need to talk with is going to be there in the courtroom that day. All right.
All right.
I will say this, that judge has more patience than many of them that we see. That lady would have been shut down like 10 minutes ago with a lot of the other judges. Let's change it up. Let's go up to Lake County, Ohio, Judge Collada.
R1421. The defendant is present with counsel Michael Goldberg. A 6-count indictment was filed in this case on October 8, 2025. Counts 1, 2, and 3 are illegal use of a minor or impaired person in nudity-oriented material or performance, felonies of the second degree, in violation of revised code 2907.323A1 with forfeiture specifications. Counts 4, 5, and 6 are voyeurism, felonies of the fifth degree, in violation of revised code 2907.08C. The state has offered for the defendant to plead guilty to counts 3, 4, and 5 with the forfeiture specification to count 3. It is the state's understanding that today the defendant would like to withdraw his previously entered pleas of not guilty and plead guilty to these 3 counts. It is the state's understanding that the defendant will also voluntarily forfeit an additional cell phone and Android that is not included in the forfeiture specification, and there is no agreement as to sentencing.
Mr. Goldberg, does that sound accurate?
It does, Your Honor. I'll just also state for the record that I've had a chance to meet with Ms. Gold on a couple of occasions. I've reviewed all the evidence, both that she could provide to me in the regular channel of discovery and that was of a more sensitive, privileged nature. I've discussed everything with my client, and he understands his constitutional statutory rights. He understands the benefits of this plea and the potential penalties, and he will make a knowing and voluntary plea here this morning.
Thank you. Ms. Gold, it's my understanding that the victim would like to be addressed to court. Is that accurate?
Yes, Your Honor.
We'll hear from them at this time. So whoever it is that wanted to address the court, to state your full name, please, so we know who's speaking, then you can say whatever you'd like me to know.
My name is Giovanna Priola.
What is it?
Giovanna Priola.
Can you spell your last name?
Priola.
Thank you.
Your Honor, I feel the plea deal is too lenient because most days I still have trouble showering and most nights I still have issues sleeping along with nightmares even 6 months later. I feel due to the overwhelming amount of evidence it should go to trial and the defendant should be held responsible for all 3 counts on both charges. I feel there's absolutely no reason to drop any charges or lessen them because what the defendant did completely changed my life and cannot be undone.
All right, thank you. Mr. Jefferson, were you able to hear what the prosecutor said earlier here this morning, as well as what your attorney just said?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to count 3, 4, and 5. And I'll go over those charges with you. Remaining counts will get dismissed. We would defer sentencing to get some reports and evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Let's get started then. How old are you?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, I do not.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nothing.
Now, you should have been served, you would have been served with a copy of this indictment. It looks like you got it sometime back about the first, second week of October. Do you remember that, this document that sets forth the charges?
Yes, I do.
Did you have a chance at some point to look that over?
Yes.
Now, in this indictment, you're charged with 6 counts. You're pleading guilty to 3 of those. Count 3, the first count you're pleading guilty to, alleges, and what you'll be admitting to, is on or about May 23rd, 2025 in Wickliffe Lake County, Ohio, that you did photograph a minor who is not your child or ward. You did that, photographed them in a state of nudity, or you created, directed, produced, or transferred any material or performance that shows the minor in a state of nudity. That conduct constitutes the offense of illegal use of a minor in a nudity-oriented material performance. It's a felony of the 2nd degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Charge also carries with it a forfeiture specification, which alleges during the commission of the offense that you had in your possession a black Samsung phone which was used as an instrumentality. An instrumentality is some type of property that's used to facilitate the commission of an offense. Here it's alleged you used this black Samsung phone to commit or facilitate the commission of the offense. I just read to you the purpose of the specifications. That at the time of sentencing, any right, title, or interest you have in that property will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
For the purpose of them disposing of it and getting rid of it. Any questions then about count 3 with the forfeiture specification?
No, Your Honor.
And count 4 is the next charge you're pleading guilty to. Counts 4 and 5 actually, they're same charge, just different dates. Count 4, it's alleged to have occurred on May 17th, 2025. Count 5, the conduct's alleged to have occurred on May 22nd, 2025. And in both of those counts, it's alleged that in Wickliffe Lake County, Ohio, that you did knowingly commit trespass or otherwise secretly or surreptitiously videotape, film, photograph, or otherwise record a minor with initials of GP in a place where a person has a reasonable expectation of privacy, and you did it for the purpose of viewing the private areas of the minor. That conduct constitutes the offense of voyeurism. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to counts 4 and 5?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there are 3 other charges in the indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about any of those 3 charges?
No, Your Honor.
Well, then before I can accept your guilty plea to the 3 charges I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial. Trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 3 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of these charges. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right
yes.
to have a trial in this case?
Yes, Your Honor.
Now, if we had a trial, you'd have the right to have an attorney represent you at the trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, first the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges. That presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges at a trial. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would be bringing witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you at trial?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that. You don't have to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court to issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that is your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if you went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up any right you have to appeal a guilty finding that I will enter if I accept your plea, as well as any other issues that you could have raised or brought to my attention that could be raised in the future. You're giving up all those. Do you understand that?
Yes.
Well, not any sentencing issues, but any rights, any issues you could have raised up to this time. That's what I meant to say. You understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions,
Do you understand them all?
Yes.
You still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty in count 3 to a felony of the second degree. This offense is what we call a qualifying offense, and it's simply called a qualifying offense because it was committed after March 22nd of 2019. After that date, all felonies of the first or second degree are subject to indefinite sentencing. Indefinite sentencing means that a minimum sentence and a maximum sentence will be imposed if a prison sentence is imposed. In this particular matter, if a prison sentence was imposed, I would select a number in the range of 2 to 8, 2, 3, 4, 5, 6, 7, 8. And that number, whichever number I selected, would be the minimum sentence you would have to serve. You understand that?
Yes, Your Honor.
Now, in order to determine the maximum sentence, it's simply a mathematical formula. You take half of whatever the minimum sentence is I select, you add that half to the minimum sentence, and that becomes the maximum. So I'm going to give you a few examples just to make sure we understand. If I selected 2 years as the minimum sentence, Half of that is 1, you'd add the 1 to the 2, your maximum is 3. So it'd be an indefinite sentence of 2 to a maximum of 3 years. If I selected 6 as the minimum, half of that is 3, you'd add that to the 6, the maximum would be 9. So it'd be an indefinite sentence of minimum of 6, maximum of 9. And likewise, if I selected 8, which would be the maximum for the minimum sentence, half of that is 4, you'd add that to the 8, your maximum would be 12. So it'd be the maximum sentence you face on count 3 is an indefinite prison term of a minimum of 8 years, maximum of 12 years. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, the other remaining counts, I think they're 4 and 5, is that correct?
Yes, Your Honor.
4 and 5 are felonies of the 5th degree. Those are each punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range. So if I impose the prison sentence, I'd select one of those numbers, 6 through 12, and that'd be the number of months you'd have to serve for that particular count. Do you understand that?
Yes, Your Honor.
Now, since there are 3 separate offenses here, if I impose a prison sentence, I would impose it on each count in the manner that I just described. And then as the judge, I had the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You'd serve them at the same time. Consecutive means one after the other. So you'd serve, if all 3 were consecutive, you'd serve the prison terms on the felonies of the 5th degree first, whatever those were. Then you'd serve, after you completed that, the indefinite sentence on count 3. You understand that?
Yes, Your Honor.
So in this particular case, if I impose the maximum sentence on each count, the 8 to 12 plus 12 plus 12, 8 to 12 years plus 12 months plus 12 months, the maximum sentence you face in this case is an indefinite prison term of a minimum of 10 years, maximum of 14 years in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole or any type of supervision in any of the courts or agencies?
I am on GPS ankle monitoring.
That's for this case, though, right?
Yes.
So that's a bond condition. I'm talking about for other cases that may have occurred previously.
No.
So you're not on probation to another court for any other prior case or
No, Your
post-release
Honor.
control or anything like that? Do you have any other charges pending against you anywhere else?
No.
If a prison sentence is imposed in this case, upon your release from prison, you would be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you completed whatever the prison sentence was. And in this particular case, it would be 5 years. It would be mandatory and it'd be 5 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, that you serve more restrictive sanctions, including local jail time. Or I could terminate or end your probation at that point and send you to prison then. If I did it at that point, again, it could be for that period of time I told you before, up to a maximum of indefinite term of 10, maximum of 14 years. Do you understand that?
Yes, Your Honor.
That would also be, or could also be, consecutive to any other prison sentence you may be serving for some other case if something else happened, or that you're being sentenced to at that time if something new happened. You understand that?
Yes, Your Honor.
Now, in regards to the indefinite sentence that I just explained to you for count 3, there's some other things I need to tell you about that. In terms of that minimum sentence, whatever the minimum sentence is that is imposed by the court, there is a presumption, a rebuttable presumption, I'll explain what that means, that you be released after you've served that period of time for the minimum sentence. Now, that's not guaranteed, but there's a presumption that you should be released. That presumption, however, could be overcome if the Department of Rehabilitation and Corrections, the prison system, is able to establish at a hearing that while you were confined, you violated rules of the institution, prison rules, you weren't sufficiently rehabilitated, you were a threat to the community. If anything like that was present, they would have a hearing. And if they were able to, which you would be present at, have a right to be present at least. If they were able to establish that at the hearing, then you wouldn't be released at the minimum sentence. You would remain in prison. They would select a new date that you could be that you would be released, and that new date would be a presumption that you'd be released at that time, but the same procedure could be followed. Again, it's not guaranteed. If at a hearing they establish that you still were committing violations of the rules, you were a threat, you weren't sufficiently rehabilitated, they can keep you in prison again. However, under no circumstances can they keep you in beyond the maximum sentence. So hypothetically, if I gave you the maximum sentence, 14 years, they'd have to be released you at that 14 years, even if you misbehave every day you were there. They'd have to release you at that point. You understand that?
Yes, Your Honor.
Also, if I did impose a prison sentence, you would have the ability to earn what is called good time credit, which could reduce the period of time that you serve in sentence, and that's done by participating in programs, etc., while you're in prison. Now, again, that's not guaranteed, but you would have the right to earn anywhere between 5 to 15% credit off your sentence. In terms of that the first issue I was explaining to you about the getting out at the minimum sentence, I have no say in that. I have nothing to do with that. In regards to this good time credit, if you did earn good time credit, there's a presumption that you should get it, but it's not guaranteed again. And in that regard, the prison officials would notify me or whoever's sitting here at that time in this seat, and it'd be up to the judge. If the judge wanted to not approve it, he would have or she would have a hearing, which you would be present at. And after that hearing, the judge could approve or disapprove of that credit. If there's no hearing, though, it has to be approved. You understand that?
Yes, Your Honor.
Now, in addition to the possible prison sentences that I just explained and the circumstances all about that, there's other sanctions that could be ordered. You could be fined in this case. Count 3, the felony in the second degree carries with it a possible fine of up to $15,000. The other 2 charges carry a possible fine of $2,500 each, so altogether there's a maximum fine of $20,000. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution to the victim for an economic loss the victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
Also, in regards to the forfeiture specification, at the time of sentencing, you'll be ordered to forfeit the property that is described in that specification, and apparently there's also some agreement between the parties regarding another phone that's going to be forfeited at the time of sentencing. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Lastly, since you are pleading guilty to a sexually oriented offense, at the time of sentencing, you will be advised by the court of what your obligations will be to register as a sex offender. You'll be required to, you'll be classified as a Tier 2 sex offender, correct? Tier 2?
Yes, Your Honor.
Tier 2 sex offender, and you will be required to register in person at the sheriff, the county sheriff for the county where you reside, and then also where you work or go to school if that's applicable, if it's a different county. Do you understand that?
Yes, Your Honor.
And you'll be required to do that. I'm going to explain this in more detail at the time of sentencing, but it'll be every 180 days for 25 years. Do you understand that?
Yes, Your
Which would
Honor.
start after any incarceration, if any incarceration is imposed. Do you understand that?
Yes, Your Honor.
And again, you'll get more specific details about that. I just need to make sure at this point you understand that that's a consequence of and something that's going to happen as a result of pleading guilty here. You understand that?
Yes, Your Honor.
Now, a few moments ago I explained the possible prison sentence you face. I used the word possible. Prison is not mandatory with any of these charges. With each of these charges, you are eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means it'll be considered if that's what you're asking for. But I'll look at all the information presented and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, while you are eligible for community control sanctions, I need to advise you that count 3 of the felony of the second degree carries with it a presumption for prison, which means there is a presumption that the court would have to impose a prison term unless certain findings could be made by the court to overcome that presumption and allow me to put you on community control sanctions. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, Your Honor.
Further, if you are on probation, you violate any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, including an order that you serve time in our Lake County Jail, or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it would be for the same period of time, or it could be for the same period of time that I explained earlier, up to a maximum of an indefinite prison term of a minimum of 10 years, maximum of 14 years, which can also be consecutive to any other prison sentence that you may be serving for something else at that time, or you're being sentenced to. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to court. Prosecutor has a right to recommend the sentence to court. The victim has a right to speak at sentencing. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what the sentence should be, it is just what I said. It's a recommendation. I don't have to follow any of the recommendations. Even if it's agreed to, I don't have to follow it. If I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Do you have any questions for me about the potential penalties you face by pleading guilty?
No, Your Honor. No
Understand all the
questions.
possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him review everything with you, go over the reports, answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this point regarding anything we've just talked about, regarding the rights you're given up, the penalties you face, what you're pleading guilty to? Any questions at all for me?
No, Your Honor.
Do you need any more time to speak to your lawyer before we go forward with the actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me, excuse me, what she believes the evidence would show if we had a trial. I want you to listen to her because then I got some follow-up questions for you about that, all right?
Yes, Your Honor.
Let's go for the state.
Thank you, Your Honor. The facts would show that during the time frame in the indictment, the defendant was living with his ex-girlfriend Angela Priola and Miss Priola's 16-year-old daughter, minor victim GP. They resided at a house in Wickliffe, Lake County, Ohio. On May 17th, 2025, May 22nd, 2025, and May 23rd, 2025, the defendant set up his Samsung phone in the bathroom of the home where minor victim GP had a reasonable expectation of privacy to secretly record her. On each date, the defendant recorded video of minor victim GP going to the bathroom and or showering while she was in a state of nudity to view her private areas.
Mr. Jefferson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as they were just presented? Are they true? Did you do what she said?
They are true, Your Honor.
Very well, then, regarding count 3, charging with illegal use of a minor in a nudity-oriented material or performance, a felony of the 2nd degree, what is your plea to that count?
Guilty.
What about the forfeiture specification regarding the use of the phone as an instrumentality? What is your plea to that?
Guilty.
As to counts 4 and 5, each charging with voyeurism, each felony is of the 5th degree, occurring on different days, what is your plea to each of those 2 counts?
Guilty.
All right, this time, I have in my possession here a document called a written plea of guilty and judgment entry. which sets forth and explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you sign it here in open court. Excuse me. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Goldberg, is that accurate? Did you review this with Mr. Jefferson, read it over to him, and answer his questions?
That is accurate, and I did do so, Your Honor.
And did he indicate an understanding of that to you when you did that?
Yes, he did.
Is that correct, Mr. Jefferson?
Yes, Your Honor.
So you understand what the document says?
Yes, Your Honor.
Any questions for me?
No questions.
It also appears that you signed the document a couple times. Did you in fact sign it?
Yes, I did.
You witnessed that, Mr. Goldberg?
Yes, Your Honor.
Ms. Gold, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, illegal use of a minor in a nudity-oriented material or performance, felony of the second degree in violation of 2907.323A1 with the forfeiture specification, as well as counts 4 and 5, voyeurism, each felonies of the fifth degree and each in violation of 2907.08C. The remaining counts will get dismissed at sentencing, but I'm going to defer sentencing, order a pre-sentence report investigation, victim impact statements. Anything else you're requesting report-wise, Mr. Goldberg?
No, Your Honor.
As for bond, where were you this morning, Mr. Jefferson? You're supposed to be here at 9 o'clock for this sentencing. We had to sit around and wait for you to get here.
I apologize. I was not made aware of the time, just the date, and that is my fault. I was on my way to help.
You were made aware of just the date, so we're going to show up at 3 this afternoon, 6 o'clock tonight?
No,
So if you didn't know a time, you knew a date, why wouldn't you make some attempt to find out what that time was, or be here at midnight so you make sure you're here for sure?
That was a lack of responsibility on my part.
I don't get it. You weren't told the time by who? Your lawyer, I guess you're saying?
Correct.
So why wouldn't you, when did you find out when the hearing was?
A few days ago. I had the dates wrong. I thought it was tomorrow. I thought tomorrow was the 23rd. I was incorrect.
It's the second time this has happened. No, these are serious charges here. I mean, we think you take it serious.
I do, absolutely.
You don't.
Can I speak to this, Your Honor?
Sure.
So this was originally scheduled for the 19th to accommodate the state and the victim. It was moved to today. I did inform my client it was moved to the 23rd. He asked what time. I said it's going to be early. That's before I had the time. I never corresponded with him. Obviously, it's his responsibility to be here on time. When I called him this morning, he was indicating to me that he thought it was tomorrow. And he turned around and got here as quickly as he could. And so that's what happened. And, you know, to the extent that I didn't give him the exact time, that's my fault, but we know that it's ultimately...
Yeah, but if he gets a date and he has a court date and doesn't have a time, the first thing he should be doing is getting on the phone saying, what time is this hearing? When were you going to show up? So even if you thought it was tomorrow, when were you going to show up tomorrow?
I was going to reach out to my attorney today and ask for a time.
Well, again, if you were taking it seriously, you would have done it the day you got the notice instead of waiting till a day before to do it.
I would just state, Your Honor, that he's taken this very seriously. He's agreed to a forfeiture that's outside of the indictment. He's shown up at my office every single time, and this is, I believe, even though it's comes on a very serious matter, he made an honest mistake.
Now, will the court will continue defendant's bond and order of cognizance with an order that the defendant have no contact with the victim or the victim's family, and follow all terms and conditions of the protection order. So, Mr. Jefferson, the matter is being referred to the probation department for the reason that's going there so they can prepare a pre-sentence investigation. The way they get the information they need to prepare this report is they're going to conduct an interview with you. It's important that you show up on the right day, at the right time, for the purpose of that interview, because if you don't show up, then they're not able to, and they don't have an interview, they're not able to do a report. And without a report, I'm not even able to consider probation as an option. So if you don't know when it is, if you don't know the time, it's your responsibility to find that out. If you think it's the next day and you don't show up, you're out of luck. So you better be damn well sure you know what date it is and you show up at that time. It's also important that you're open and honest with them when you meet with them, because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they'll let me know. I certainly would consider that as sentencing. You understand that?
Yes, Your Honor.
So you're going to leave here now. You're going to go over to the probation department. You're going to fill out some initial paperwork. Then you're going to get a date to come back for the interview. So make sure you go there when you leave here right now. You know where that is, Mr. Goldberg, right?
Yes, Your Honor.
So your lawyer will bring you over there or tell you where to go. But make sure you go there when you leave here now.
Yes, Your Honor.
Mr. Gold, anything else? Ms. Gold, anything else for the record?
Your Honor, because the defendant is on an OR bond, I would ask if we could put the sentence
Oh, yeah,
date on
I
the
will do
record.
that. When is that, Mr.?
February 9th,
Right.
3 o'clock, sir.
So your sentencing is February 9th at 3 p.m. That's here. So that's what time you need to be here for your next court date. Again, this OR bond means you have to appear at all future court dates, and if you fail to do that, you can be prosecuted for a new felony and get up to 18 months in prison on that, which could be consecutive to anything that happens on the original charges. So it's obviously important to show up at all future court dates. But again, before that February 9th date, you're going to need to go to probation department, so make sure you do that as well.
Yes, sir.
All right. Mr. Goldberg, anything else?
No, Your Honor, thank you.
Thank you.
I'm going to take it a step further from what Judge Collada said. He was saying that if this guy took it seriously, he would do X, Y, and Z. I would argue that if he was taking things seriously, he never would have done these things at all. And I can say he never would have done them and leave out the word allegedly, because there's nothing alleged about this at this point, because he has gone ahead and pled guilty. So, yeah. I'm just saying, the more and more court we watch, the more and more I shake my head in disbelief at just how people conduct themselves and the stupid decisions they make and everything else. But you don't need that lecture from me. You feel the same. I know it because we talk about it all the time. Let's go to Michigan, spend some time with Judge Mom.
So that's not new information to this court. This court knows that your client travels out of state for work. Given the significant allegations that are present in this matter, the court has serious concerns for the safety of the public, even the public that's not within this location or the state of Michigan. And your client had previously relocated and was not living at the home when these allegations occurred. So your client wasn't residing, your client was residing with your dad at the time, with his dad at the time of these allegations as well. And counsel, I understand that your client may have work obligations that take him out of the state of Michigan, but this court has some serious concerns for the safety of the public given these allegations that have occurred.
May I propose this? Would
Just
the
one
court
moment,
be-
just one moment, counsel. I'm just waiting for the prosecutor to come in to place that on the record, his opinion regarding Mr. Miller's ability to travel out of the state, given the nature of these charges. Counsel, your appearance for the record, please.
Good morning, Your Honor. Stephen Kaplan on behalf of the people.
Good morning. And there's a request by Mr. Coyle to allow his client to travel out of state for work purposes.
Your Honor, if I may.
Yes.
So Mr. Coyle and I had a conversation regarding that issue, and the people view it from this perspective that it's good for his client to work. We don't think he's going to vanish, Your Honor. I think Mr. Coyle is good client control. Therefore, we would not object.
Okay, and counsel, I can appreciate that. However, while it may be good for Mr. Miller to work, it's also, given the nature of these allegations, the seriously disturbing allegations that are present in this case, the court has significant concerns for the safety of the public at large, whether Mr. Miller is in the state of Michigan or elsewhere.
Of course.
So the court's not inclined to grant that request. You had one other thing you wanted to address, Mr. Coyle?
Yes, I was going to suggest this as a proposal. Can we attach Mr. Miller somehow, some way to pretrial services, and those times when he needs to leave the state of Michigan for his employment, let pretrial services know when he's leaving and when he's coming back. I understand the court's concern with regard to safety of all people.
Whoever's phone is on needs to be turned off.
He's posted a bond, so there's significant money at risk. While I understand your concern, that same concern also applies here while he's out on bond in the state of Michigan. And he's simply, I mean, his employment is a very important part of his life, and as anyone's is. And I mean, that travel is necessary for his work. So if pretrial services can overlook it, or if the court feels more comfortable there, that way, I ask you to consider that as well.
So counsel, the concern that this court has is that, or not the issue that this court has is that whenever this court sends a request for pretrial services investigation or report, we don't get anything back. I don't know if they're ever interviewed or not. So I don't know how that would attach at this stage. I don't know if they're specific to Third Circuit Court, or they just pick and choose which courts they're going to supervise or interview defendants with. I don't know how that works. When is your client expected to travel for work?
So that's a tough question, Your Honor, because the way it works is this: on Fridays at his company, Plug Power, they meet with regard to when these individuals need to travel out of state and what state they're going to. And they then make the arrangements to do that the following week. A week might be Mr. Miller having to go to St. Louis, Missouri for 2 days, and then perhaps travel to North Dakota and then back to Michigan. So there is no set time. It's just a part of his employment.
Well, Mr. Miller is going to have to communicate with his supervisors as to how he can be available via Zoom or otherwise, because this court's not permitting him to travel out of state at this time.
Very well, thank you.
Thank you. Bond and conditions are continued.
Thank you.
Have a good day. We are on the record in the matter of the state of Michigan versus Dominic Keithley, 251460. Does Mr. Kaplan know he needs to be zoomed in?
I just told him.
Oh, okay. I don't know if he was, okay. All right.
Good morning, Judge DeSantos, Leo Ryan, on behalf of Mr. Keating.
Good morning. Hold on, counsel. I show Ms. Bates as the attorney of record. Have you substituted in?
I spoke to her, we ended up in, on Zoom in Southgate, Miss Bates, I think. I don't, the woman said she was gonna represent him, and then I said I was paid by him, so.
If you're a retained counsel, there needs to be something in the file. There needs to be a substitution of attorney. I don't have that.
Okay.
So once we have that, we'll recall the case.
I'm sure. Hello?
There should be one you can get at the window or otherwise. Here, that's this one.
Do you have her phone number so I could call her to get her?
Council, it's all on this, it's all on the website, State Bar of Michigan website. You can get her information and otherwise, but you should know that there's a procedure whereby attorneys can appear in a case, and that has to be a document, whether it's by appearance, if there's not a prior attorney, or a substitution of attorney if there's a prior
Well, I
attorney.
don't know if she was his
So-
attorney or not. She was showing up there. She.
Council, I'm not done speaking.
Okay.
If you looked at the file, it would show Ms. Bates's name on the file as the attorney that was appointed to represent him.
Okay.
If you were retained after that, then you need to file a substitution of attorney.
Okay.
Thank you. All right, let's go on the record in the matter of the State of Michigan versus Todd Steiger, 251646.
Good morning, Brian Mashney, PA 5797.
Okay, thank you. And Mr. For Mr. Steiger.
Good morning, Your Honor. Michael Piechnik here on behalf of Mr. Steiger.
Thank you. And Mr. Steiger, your name for the record, please.
Todd Steiger, Your Honor.
All right, today's date scheduled for the probable cause conference. Council?
We've asked that we be given a date for our an exam. I think the date that we had discussed with the prosecutor, the next available date was January 8th, given the 1st is a holiday.
Okay, and if you can go over waiver, I think that it's already been established. If you can go over waiver of time with your client, please, counsel.
Mr. Steiger, you understand that the statute requires that the prosecutor in this court hold your preliminary exam within 21 days?
Yes.
And you understand that you and you alone have the ability to waive that if you so choose?
Yes.
And you understand that by waiving it, you're not giving up any rights, you're not admitting to any guilt or anything, you're simply just allowing the state and the court to hold that exam past the 21 days?
Yes.
And you're willing to do that in this case?
Yes, sir.
Thank you, Mr. Steiger.
All right, the court will note that time has been waived on the record. And the court will schedule this matter for exam on January 8th at 1:30 p.m. Witness exhibit list by January 5th. And then bond and conditions will continue. Sir, if you're to test right now, what's in your system?
There should be residual THC, but I haven't smoked since I got arrested, miss.
Okay. All right, very good. We'll see you back on January 8th. Thank you. Have a good day.
Okay, thank you, Your Honor.
Thank you. And then
Your
we're
Honor,
on the record in the matter of the State of Michigan versus Frederick Moore Jr., 251615.
Frederick Moore.
All right, thank you, Mr. Moore. And counsel for Mr. Moore?
Good morning, Your Honor. Michael Piechnik here on behalf of Mr. Moore. I apologize. I thought Mr. Kaplan was going to put his appearance on first.
No, that's okay.
I'm sorry, Your Honor. Stephen Kaplan, Your Honor, on behalf of the people.
Okay, thank you. All right, Mr. Moore, you're in a vehicle, but you're not driving. Is that correct?
I'm parked. I'm not
Okay.
driving.
Okay, very good. And so today's the date scheduled for the probable cause, the adjourned probable cause conference in council.
We're requesting this be set for an exam as well,
I'm presuming January 8th.
if it's available. And just a quick question, Mr. Steer, did you say 1 or 1:30?
1:30.
1:30, thank you.
So we'll set this for exam on January 8th at 2 p.m. Council, I believe, if you can go over the time waiver with your client as well, please.
Yes, Your Honor. Mr. Moore, you understand that statute requires that the prosecutor in this court hold your preliminary exam within 21 days of your arraignment?
Yes.
And you understand that you and you alone have the ability to waive that right and allow the court, the prosecutor, to hold this outside of that 21 days?
Yes.
And it is your choice to allow, to basically waive that right and allow this exam to be conducted slightly outside of the 21 days in this instant case.
Yes.
Thank you.
All right, the court will note that time has been waived on the record. Witness exhibit lists are due January 5th. Bond and conditions are continued.
Thank you, Your Honor.
Thank you. Have a good day.
You as well.
Thank you. All right, let's go on the record in the matter of the State of Michigan versus Nicole Unsworth 251086. And counsel, your appearance for the record, please.
Your Honor, Stephen Kaplan on behalf of the people.
Najad Mihan appearing on behalf of Ms. Nicole Unsworth, P59371.
Okay, Ms. Unsworth, your name for the record, please.
Nicole Unsworth.
Okay, I need you to turn on your camera.
Okay, hang on. I'm sorry. There we
Your
go.
Honor, if I may.
Okay,
Your Honor, we have a waiver of the exam to circuit court. People have no objections.
okay. And so, you understand that you do have the right to have a preliminary examination, or it must be shown that a crime was committed and probable cause exists to charge you with that crime. You understand that?
Yes.
And you also understand by waiving your right to your preliminary exam, you will be bound over to circuit court for further proceedings on the charges in the complaint and warrant. Do you understand that?
Yes.
And have you received notice of those charges in the complaint and warrant?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No.
Counsel, do you have an objection for the court indicating via Zoom on both your signature line and your client's signature line?
No.
All right, the court will note examination having been waived, defendant is bound over to circuit court for further proceedings. You are to appear in circuit court on January 6th at 9:00 in the morning
Okay.
on the charges in the complaint and warrant.
Thank
Okay.
you.
Thank you.
Conditions will continue. Thank you. Have a good day.
Thank you.
Thanks.
Let's go off the record for a moment.
Very good.
Okay, friends, she's full of cheer this morning. Little grumpy. Sometimes we get that from Judge Mom. Let's switch it up though. Let's go from Judge Mom to Judge Dad. See what's going on there.
It looks like Judge Mullins, I believe I was absent that day, as I recall it. I don't know if you remember, Lisa, but I was absent, and Judge Mullen, my place, I think,
Yeah, you're correct.
set a
Judge.
5,000, 10% bond and ordered him not to have any contact with Adam Grote, not to enter or go near 3750 Brookshire and Trenton, no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs, no firearms, no dangerous weapons, and the defendant was required to obtain a tether within 24 hours of release from custody. So, hang on one second. See,
Yeah.
I'm gonna talk to you about bond sheet marijuana. Well, we met, and need to talk to you about that for 2 weeks. Okay, so then I got a signing on record on the, he was in Chattanooga, failed to acquire the GPS. Court found by preponderance of the evidence that the defendant violated his bond condition by failing to acquire a GPS. I revoked the release, forfeited the bond, and ordered $50,000 cash or surety. So, what are we gonna do on this one, Mr. Westmoreland? I mean, I could take, you can just argue bond, or if you want to have a bond hearing as to whether or not he failed to acquire his GPS tether as ordered by Judge Mullins, that's fine too. What is your preference here?
Your Honor, I would just ask that this matter be reset, and I will argue bond on behalf of Mr. Flesher.
Sure, go ahead.
Your Honor, I would like you to know that Mr. Flesher is currently homeless and he is currently unemployed, so he has no means of paying for any sort of tether. He's not currently on probation or parole. I don't believe he has any prior criminal history. At least he indicated to me he did not. He has no other pending matters out of any other court. And after speaking with Mr. Flesher at length this morning, he did assure me he would be appearing at all future court dates, and he does understand the importance of doing so. I believe last time he felt that he was threatened and he could not appear. But moving forward,
Wait a minute, say that again?
Mr. Flesher indicated to me that he felt that he was in grave danger and he could not appear.
Danger by who? From who?
Your Honor, I'm not exactly sure at this time, but Mr. Flesher did assure me he will appear and he understands the importance of doing so.
Did he make any police reports?
Not to my knowledge.
I don't know if we if Judge Mullins ever signed the complaint. Wonder if we can send that, can you send that over to her? Oh, wait a minute, she signed the warrant, oh, she did sign the complaint. Why did you leave without getting a GPS tether, sir?
I feel that my life is in danger, and that's what set this whole thing in motion.
Your life is in danger.
I have no interest in defrauding Grow It, Adam, or
I want you to talk
anybody
about
else.
hang on. I want you, hang on. I want you to talk about the case. You should not be talking about the case.
Okay.
I don't know why you're telling me your life was in danger. Did you tell Judge Mullins your life was in danger when she was setting the bond?
Yes, I've told everybody.
He tell you this, detective?
He did not, Judge. Me and Mr. Flesher has not had any real conversations to that effect.
You told Judge Mullins at the time of the arraignment that you felt your life was in danger? I don't want to put words in your mouth.
A tether tracks to exactly where I am.
Say that again?
The tether would track to exactly where I am.
We know that.
I am moving. I was moving around to try to avoid. I have to give you the whole story, or you don't get the whole picture. Yes, my life is in danger, absolutely 100%, and I have documentation that proves it inside and out. That's why I'm more than happy to come to trial. I'm more than happy to speak to a judge and a real lawyer and everything else. I have no problem with that.
I'm a judge and he's a real lawyer and he's a real detective.
Okay.
Listen, Mr. Fleeser. You were ordered to get a GPS tether. I know not what you're talking about, sir. I do not know what you're talking about. Have you ever treated for mental illness, sir?
No, sir.
You work?
I haven't worked in a long time, sir.
How long?
I don't have a problem working. I'm not a bum. I have skills. I'm more than
Nobody said you
capable.
were
My
a
phone
bum. How
calls are
long since you've worked?
since. So you mean since I've been paid for work? Probably about April 2008, maybe.
Where do you live now?
I'm denied employment. My phone calls are intercepted.
Where do you live now?
Visits to law offices are intercepted.
Listen
Just
to my
telling you,
question.
I want to be honest with you.
Well, I want you to be honest with me too. Where do you live now?
I go from hotel to hotel to hotel to outmaneuver whatever the heck it is that's coming after me. I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit. The code is basically how they get rid of people they don't care for.
The federal government you're talking about?
Correct.
Oh, boy.
It's none of it's legal by any means, but it's very damning to say the least. So I kind of keep that to myself, but it doesn't allow me to survive. Like I said, I'm not choosing to have my calls intercepted. I'm not choosing to have my automobile sabotaged, my family's home sabotaged. The list goes on, and that's why I know you don't want to go into detail. But I have to be honest with you. Yes, my life is in danger. That is the whole reason why I'm here. Why I took the mail that I took.
All right, you should not be saying that. You should not be saying that. You should not be saying that, sir. You just should not be saying that. I'm trying to caution you, not listen to me, please listen.
Go ahead.
You shouldn't be making admissions. You should not be making statements that are against your interest. I'm concerned here. I don't know what to tell you. I'm gonna set $2,000 cash or surety. $2,000 cash or surety that you're going to have to post. And this time, I'm going to change the bond conditions ever so slightly. You're not to have any contact with Adam Grote. You're not to have any contact with prosecution witnesses. You're not to enter or go near 3750 Brookshire in the city of Trenton. You're not to possess firearms. You're not to possess dangerous weapons. You're not to purchase, possess, or consume alcohol or illegal drugs. You're not to be released until fitted with a GPS tether. You're not to be released until fitted with a GPS tether. So even if you post the bond, you're not going to be released until they can fit you with a GPS tether. Also, I'm going to order you to attend a psychological evaluation and treatment. You can call the probation department. So if they recommend probation's going to give you some names as to where you can go. You're to attend a psychological evaluation and treatment if recommended. So those are the bond conditions. I'm adding a couple that Judge Mullins did not have. And you have never heard anything about this at all, Sergeant?
I have not, Judge. I know there was some conversation about his monies being funneled out of his bank account, but we didn't get into a conversation involving people coming after him.
All right, so Mr. Fleezer, I'm sorry. I'm going to give you a new date. It's going to be, what, January the 6th, is it? Lisa?
January 6th at 10 o'clock.
January the 6th of 2026 at 10 a.m. I hope you didn't pre-try that with those guys. I told them we needed an Arabic interpreter.
His son spoke for him.
Yeah, I can't do that. It's a criminal case. I just can't do it.
I understand.
I just can't do it. I tried to tell them that. I mean, it's a criminal case. I'm supposed to get an interpreter, so I can't. I'm sorry. I just can't do it. That's the way it is, Mr. Fleezer. I'm sorry. So I want you to get a psychological evaluation and treatment. You can post $2,000 and you're not going to be released until fitted with a GPS tether. Okay? Do you understand, sir?
Yes, but I don't have $2,000.
I'm sorry. You should have shown up. You should have shown up. You didn't get your tether and you left the state without.
I was told that the actual judge wouldn't be there.
What's that?
I was told the actual judge wouldn't be there, that somebody would be sitting in who doesn't actually normally be there. Plus, the lady that I spoke to, that was the judge, had the same name as you, sir.
No, she did not have the same name as me. It was Judge Mullins.
It did on the screen when I talked to her, because I was wondering why it was McNally, because that was the paperwork posted on her house.
Okay, listen. You were in front of Judge Mullins. You were in front of Judge Mullins. She told you to get a GPS tether, you didn't. I'm not gonna argue with you. You're gonna have to post 2,000 and they'll give you a GPS tether. If you post the bond and you get the tether and you are released, I want you to get a psychological evaluation and treatment, okay? They don't need to
Sure.
come in here. I already told them to go down the home.
I know, Judge, he can speak English. He understands. it.
No, Mr. Muhammad, come on. He told
Judge, we
me
all
he
set?
could just, yes.
Thank you,
He
Judge.
All right,
told
thank
me
you.
he told me he
So
could
that-
speak a little bit, and then he wanted to have his son interpret for him. And I can't do that on a criminal case. Call the state court administrator's office. They're gonna tell you that. I mean, I can bend it on a civil infraction just a little bit, but
I understand.
it's not my call. I just do what everybody tells me to do here.
I understand. It's just we discussed this whole case in England. So that's why I was.
Why did he tell me he just could do a little bit? Why was he, when I was conferring with him, asking his son? I can't do it. I'm sorry. Marion Carriel Banks,
What can I do with the file?
have them go down the home and they'll get their notice and they're gonna have to come back. I'm sorry.
Just give me the file.
Marion Carriel Banks. Mr. Graziani is not in here on that one. People against Robinson, Brandy Monet Robinson, 25M 626-128A and B. Where is Brandy Robinson? There you are. Ma'am, you have to start your video and state your name, please.
Brandy Robinson.
You have to, there you go. Good morning to you, ma'am. How are you?
I'm
Do
good.
what?
How are you?
Good, thanks. I have a feeling it's gonna be a good day for you. Trooper Brown's not here, right, Lisa?
Not on Zoom.
Ma'am, congratulations. I hope you got insurance. You gotta slow down, but he didn't show up. I gave him 15 minutes. He's not here. Cases are dismissed. Good luck. Merry Christmas to you. Don't drive
Thank
without
you.
insurance. That's a bad thing, okay?
Okay, thank you.
Merry Christmas. Good luck. Thanks.
Bye.
Bye now. People against John Perry. John Patrick Perry, 25I 715-127. Let's see. Good morning.
You just sit right.
Who is Mr. Perry's lawyer, Lisa?
Thank you.
It's an arraignment pretrial.
Oh, you're Mr. Perry?
Yeah.
How you doing?
I'm not doing.
Good. Have a seat there. This is John Patrick Perry, 25I 715-127. I have 2 counts. Operating while intoxicated and open intoxicants. Your name, sir?
Joe,
What is your name?
John Perry,
Good morning.
John Perry. Hey, thank you.
You're here for 2 charges, misdemeanors. You have the right to a lawyer.
Yeah, because
Hang on,
I don't need a lawyer.
hang on, slow down. Just stay, hang on. Ma'am, you can stay right there. You can sit behind him if you want, but you should get a lawyer, Mr. Perry. I'm gonna give you a lawyer, okay?
I got a lawyer.
Who is this next to you? Behind you?
My way.
Oh. Oh,
I don't drive it anymore.
well, I get it, but do you want a lawyer? What is your name, ma'am? Tell me your name nice and loud.
Brenda Woodruff.
And you are married to Mr. Perry? Are you married to Mr. Perry?
No.
No, not legal.
That's legal.
All right. Okay, but you stay together.
Yes.
All right. You said something about a lawyer. Are you gonna hire a lawyer?
We have a lawyer, Sean Perry,
She's prosecuting attorney. in the
his
state.
daughter.
My daughter.
Okay, let's slow down. Let's slow down. Just slow down. Is Sean Perry here?
Yeah. Yes.
Sean? She's not here. Is it a she or a he?
He.
And she's the prosecutor?
Attorney.
For who?
Muskegon.
And she's going to represent you? But she couldn't come today?
Well, it's guilty, and that was it.
No, well, you're not, you don't want to, listen, just relax. Let me just walk you through this here, okay?
Okay.
What are you, 87 or 8? Are you 87 or 8?
Oh, yeah.
Good for you.
It was 90. He got my pilot license. And one of those.
I'm a little concerned about this.
Okay.
I'll either give you a lawyer right now for arraignment, or I am going to arraign you, and then we'll set it for a pre-trial.
Okay, whatever.
Do you want me to give you an arraignment is where I explain the charges? Listen to me very carefully, sir. I want you to look at me and just listen. An arraignment is where I explain the charges, the possible penalties, and your rights. And then I set a bond. Do you understand that?
Wait.
I'm going to give you a lawyer. We're going to give you a lawyer for arraignment today, okay? That's what I'm going to do. I'm going to give you a lawyer for arraignment. It'll take a few minutes. Mr. Graziani, you're our guy, right?
Yes.
So you can just, this is a township case. Is that still going to fall under your purview or not? Let me see.
I believe so, Judge.
No, it's a state case. So I'll give you that. And then you can just, we'll get them arraigned. I'll set bond and we'll go from there, okay? Just stay right there. You're gonna talk to this gentleman here in a couple minutes, all right?
Yeah, let's go.
Are we ready on Marion Banks?
Sorry, Judge.
People against Marion Carol Banks.
Morning, Your Honor, Nora Alloway.
27703. Good morning, Ms. Alloway. Your name
Sorry
again?
about that. Good morning, Nora Alloway on behalf of the people, PA 6528.
Ms. Vojanov, can you unmute and tell me your name, ma'am?
My name's Jenna Vojanov.
Okay, just keep your voice up nice and loud for me, Mr. Graziani.
John Graziani, P number 43387. Judge,
Sir, your name?
Mario, thanks.
All right, what are we gonna do on this?
Judge, I've spoken to, Madam Prosecutor and, in discussing the matter and looking at the logistics, it appears that we're better off in turning it over to the, civil system, the family court, Wayne County Judge.
Now, what is the name of the victim here again, please?
We have
Jenna
Jenna Vojanov.
I know that, but I was more concerned about the kids.
There's one child that's 3 months old. Her name is Lila. And so after speaking to the complaining witness on this matter, I would ask the court, keep that no contact order in place. And as for the language, it would be no contact except to effectuate any child custody order.
Okay, so defendant cannot have contact with Lila. Is it Leila?
Yeah,
How do you spell the name is all I'm asking, ma'am.
it's Lila.
Okay, and Lila, is the last name Vojanov or Banks?
Yeah, it's my last name.
So defendant cannot have any contact with Lila Vojanov except as permitted, allowed by the Wayne County Circuit Court. So I'm not going to get into that. And that's what, so that's going to be an addition. I don't know if I didn't write it down.
If I may interject, what's happening is, Mr. Banks has his sister's foster parent who would be able, and she's licensed and who would effectuate any potential visitation because of what's going on in your court.
Yes, but after speaking to defense counsel, we agreed that it would be it would be on the parties to excuse me,
The family court.
to go
I
to
get
family
it.
court. And
Who's your probation officer, sir? What's Emily's number, Sadie, again? Do you know? Wait a minute, I might have it right here. I'll be right with the rest of you here, if you just be patient with me, okay?
Hello.
Can you come in here on Marion Banks, please?
File?
Maybe. It's not a big deal. Either way, come in without the file. Thanks. So I don't know if I didn't write it down, but the intent that I was concerned about here wasn't so much about him not having contact with Daniel and Colleen and Jenna. I had that concern too, but it was more about the reason I talked to you guys at the time and said, hey, we'll try to get the victim here. And I'm talking about the mother of the child to see if something can be worked out with visitation. And the reason I did that is I recognize Christmas is coming up. So I'm going to have her prepare an amended order that says no contact with Lila Bojanoff, except as permitted by the Wayne County Circuit Court.
That sounds great, Judge.
Okay?
That's correct, Your Honor. Thank you.
Okay, so that's what I'm gonna do. Just your name.
Just hold on.
I didn't know whose case this was. He said Emily's. I'm sorry.
That's okay.
I focused, remember, I think you were in here that I said I wanted to see if I could effectuate visitation for him. It looks like everybody's agreeing to, but I didn't write it down on the order. So I want you to do an amended order that says she's not to have any contact with Lila Bojanoff except as permitted by the Wayne County Circuit Court with regard to the custody and visitation issues they have going on there. I'm sorry. I wish you well. You gotta, I won't say another word. Good luck. Thank you.
Thank you, Your
all.
Honor.
Thanks.
Again, just before we leave, I just wanted to mention that Mr. Banks, particularly because of these underlying issues, doesn't want contact, no disrespect, with folks who are involved in the situation.
You're not gonna contact him. I can't order him not to have contact, but you're not gonna contact him either, right, ma'am?
Again, Judge, what we're trying to do is just effectuate visitation down the road.
I got it. All right.
Very good.
Thank
Have
you,
a
Your
good
Honor.
day, you guys. Thank you.
Thank you very much.
Kayla Anders. Kayla Nicole Anders, 25M616-565, A, B, and C. Boy, you should have been a lawyer, Ms. Anders. You did a good job for yourself here. Your name?
Kayla Andrews.
So you're gonna plead to speeding, right? And that's on count 2. They're gonna dismiss the careless. And then you presented proof that you had a valid license and no insurance. And they're gonna dismiss those. So you're walking out with a misdemeanor dismissed, no proof of insurance dismissed, and instead of a careless, you're going to plead to 5 over, which is just it's a 1 point. It's not limited access. Do you understand that?
Yes.
Is that what you agreed to?
Yes.
To the charge 1 to 5 over, responsible or not responsible? Please accepted, careless dismissed, 155 is your fines. I'm also dismissing on motion of the prosecutor the no ops as well as the no proof of insurance. You can pay that today?
Not today.
How much do you have today?
I'll pay for that.
Are you sure? If you can't, you can. I don't mind giving you time. I'm not,
My dad said go off the pay.
your dad's a good guy, huh?
He is, very good guy.
All right, well, good luck.
Thank you.
Merry Christmas to you. You can go down the hall and take care of that. Thank you. Do I have John Garza? Where's Mr. Garza? Where's the lawyer, Mr. Bazzi at? Is he here? I don't have any other files, guys. I got,
Judge,
ahead.
it just came down in your stack of done files. I just noticed it.
Mr. Bazzi, are you ready on this? People against John Edward Gazda, 25M628-626. A. And it looks like I should have a B file, but I have no idea where it went. Do you have a B file on it?
The B file's down here. It came down in your done cases. The cases you just finished.
That's a misdemeanor too. Mr. Bazzi, your name? I don't know how that happened. I'll get the beef. John, would you go get the beef file and we'll take care of that, please? I don't know.
Judge,
Right.
especially assigned counsel and I are ready on Matthew Levens.
I don't. Okay, I just got that. Matthew James Levens, 25W702931. Okay, appearances. Your appearance. Mr. Cripps.
I'm ready. I'm here. David Cripps, P34972, appearing on behalf of Matthew Levens, Your Honor.
Ms.
And good morning,
Johnson?
Your Honor. Brittany Johnson on behalf of the people, P83513.
So what happened here? They're not going to do the evaluation until January 14th, right?
Correct, Your Honor.
Who's the Woodhaven detective on this? Can you tell me? Is Lieutenant Toller here? Ms. Johnson, I've got this note here, needs printed. So I don't know if he was printed or not. Where's your client at? Mr. Levens, your name?
Yes, Matthew
You got to tell me your full name, sir.
James Levens.
All right, so first of all, let's take care of this. I'm going to go ahead and order that you go over to the Woodhaven Police Department by noon today, December 23rd, to get printed. So you have to go over there. That is a condition of your bond. That's number one. Okay, do you understand me? You have to go over there and get printed and photographed. All right, you understand that?
I did when I was there.
You have to do it again. The judge is ordering you to.
Yeah, unless I don't have this, I can't find this CCH here, but it says needs printed, Lisa, unless you just put that on there before and it wasn't taken off. Maybe you can check on that. Let me just
Right now,
double check.
Judge.
And then I'm gonna go ahead and adjourn this, you guys.
Thank you.
To another date. It looks like they're not gonna do the evaluation until January the 14th. So you have to make sure you show up on that day, sir, for your evaluation. And then I'm thinking we adjourn this, the competency review date, hearing until, what do you think, like early February, Lisa? How long's it taking, guys? You know better than me. About 4 weeks, 5 weeks?
At least 4 weeks to 6 weeks on the competency.
All right, let's go like the third week of February, fourth week of February, Lisa.
February 17th at 1 o'clock.
Maybe another one. Maybe we go further than that because
The 24th?
Yeah, let's try the 24th.
Okay. February 24th at 10 o'clock.
All right. So, Mr. Levens, make sure you show up for your evaluation. Make sure you write down you're going to be here February 24th at 10 o'clock. That's going to be in front of Judge Hessen. And then make sure you go over to Woodhaven. I don't know where.
I'm checking right now.
Yeah, just give me 1
Was the
second.
offense date January 12th on that?
No, it was August 1 of 25, unless, you know, that works sometimes.
Let me look it up real quick.
Judge, on the 24th, would that be on your docket?
No, you're going to be in front of Judge Hessen then. We're switching over state dockets.
Judge, I remember now that I see the criminal history. There is a print segment for Woodhaven. It has a different incident date and the reference number is off by 2 numbers. So I'm
maybe
not
I
sure
better
if
send
they
him
made a
over there?
mistake.
I think you better go over there and get printed again, sir. I'm sorry. And then, Lisa, I'll just ask you to figure that out when you get a chance.
I'll follow up. Yeah.
Okay. And Mr. Levens, if you have a pen there, do you have a pen?
Yes, Your Honor.
Can I just have him call you directly in about an hour, Lisa?
Sure.
734-671. Extension 230.
Are you?
Okay? That should be it. You're all set. Call Lisa back. Merry Christmas, Ms. Johnson and Mr. Cripps. Have a great day and happy holidays. And Merry Christmas to you, Mr. Levens. Good luck. Thank you.
Thank you, Judge. Merry
Happy
Christmas.
holidays to you also.
All right, friends, let's change it up because we were there for a little while. Let's go back down to Judge Simpson's court.
Will accept the defendant's plea of guilty to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
January 20th at 9 a.m. before Judge Valvo.
January 20th, 2026, 9 a.m. Scheduled before Judge Valvo or her successor. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Christopher Brewer.
Overwater Assistant Prosecuting Attorney for the People.
Assistant Public Defender Ben Dunaway for Mr. Brewer, who is joining me at the podium now. Would you state your name for the record, Mr. Brewer?
Christopher Brewer. Thank you.
And Your Honor, we would like to set this matter for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses with 6. People have their witnesses available January 6th.
I believe so, Your Honor.
Preliminary examination in person, January 6th, 2026. Don't leave. 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Jessica Williams.
Overwater Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Justin Zade appearing on behalf of Ms. Williams. President consents to appear via Zoom. Ms. Williams, can you state your name?
Jessica Williams.
Thank you. All right, what are we doing?
Your Honor, this is the date and time set for an adjourned PCC. Last time we were here, early December, we submitted a deviation request. We still haven't received a response to that, so we're just awaiting word from the prosecutor's office.
Is that correct? The prosecutor's office is in receipt of it? What are we doing?
Checking right now, Your Honor. I do not see that in our file, so I wasn't aware of that. I will get with Mr. Zaid and make sure that he gets put in there.
For the record, it was originally sent to Mr. Cook. He indicated that he would be off the file and would forward it on to the assigned prosecutor.
All righty then. Here's what I'll do. You guys get that straightened out. I'll adjourn this to January 15, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Understood. Thank you.
No, that one. Where's Mr. What'd you do with Mr. United? I'll just call him. Of course, recalls the case People versus Lucretia Pender.
Justin Zade on behalf of Ms. Pender. Ms. Pender, can you state your name?
Lucretia Pender.
Thank you. What are we doing?
Your Honor, in this case, the court will see it is a welfare case, so there is some additional contact I need to have with the office that investigates these cases to see about what sorts of things they'd like to see as a result. You know, courts familiar sometimes they want to see a forfeit benefits, things like that. So I need a little bit more time to work on that.
That objection, I'll adjourn the probable cause to January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case People versus Devon Brown.
Overwater Assistant Prosecuting Attorney for the People.
Ray Pappen appearing on behalf of the Attorney General.
And good morning, Your Honor. Assistant Public Defender Alexis Serps with and on behalf of Mr. Brown, who's approaching the podium.
Are both of these Attorney General is?
No, Your Honor.
No, one is a state case. So. All right. Your name, sir?
Devon Brown.
Okay. So in the Attorney General matter, he's waiving.
Your Honor.
Correct. All right, sir, you're waiving your right to a preliminary examination in the case involving your failure to pay child support?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Acknowledge receipt of the information, waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute. Or will enter a not guilty plea to all counts. Pretrial will be set for
January 7th at 1:30 before Judge Conlon.
January 7th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue in that matter.
Your Honor, may I just respond briefly in that matter?
In which one?
The child support case, Your Honor.
You want to address bond?
Yes, Your Honor.
Go
Mr.
ahead,
Brown,
take a shot.
Mr. Brown would like me to ask the court either a reduction or a personal bond, Your Honor. When this matter took place, he had just recently lost his job. In Houston, he came back to Michigan to support his little brother who's special needs. He helped take care of his brother. He has been fighting for his daughter for the last 10 months. Before being brought into custody, he was working 4 different jobs. He was shipping cars, doing DoorDash, working down at Eastern Market when there was home line games, and working as a sous chef at Blue Cross Blue Shield, Your Honor. He's been in custody for 8 days as of today.
But the bond was set at 25% of what the outstanding charge was, correct?
Correct, Your Honor.
Well, I don't think statutorily I can necessarily do anything with that, and I'm not inclined to. But you can go ahead with finish your argument if you want.
Your Honor, that was the last point that I was going to make, is that he just wishes to get back to work so he can start paying on those arrearages and move this case along.
Okay, I understand that. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Understood, Your Honor.
Thank you.
And then on the other matter, his state case,
Yes.
we were just requesting an adjournment on that one, Your Honor. We got discovery late yesterday and we need a chance to review that with him.
Is there a green sheet on that one?
I
Oh, you
believe I
might
already
have given
submitted
it to
Your
me.
Honor.
I think you did. It's just other file. All right. That objection, probable cause, January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Case People versus Harold Couch.
And good morning, Your Honor. Joseph Hall appearing forward on behalf of Mr. Couch, who now stands to my right. Mr. Couch, if you could state your name for the record, please.
Harold C. Couch Jr.
Your Honor, we're here again. We are awaiting the DNA test results in this. I've spoken with Mr. Kennedy, not recently. I believe he's out of state. That's why his case is being covered. So I don't have an immediate update on the whereabouts of these results. Been requesting them for some time. And I have no doubt that the forensic center, that the forensic science division will get there. I can't say when.
And I don't have an update on the time frame. The last update I got from Mr. Kennedy was that we just don't have the report back yet. I didn't get a time frame.
During this matter, January 22nd, 2026, 9 a.m.
And thank you so much, Your Honor.
Thank you.
Your Honor, I do have an 8:30 in 34th District that day.
I'm sorry.
You're more important.
I'm sorry to hear that. So what do you want me to do? Call them and tell them cancel their docket?
Absolutely.
Or are you asking me to do something that I'm not going to do?
That's what I'm doing.
Okay.
I'm doing the second one. And if I could
You're
get.
not doing it. Talk, right? You're not doing it.
That's what it is. It's
Like Hall?
attrition. I think I could do the conflict waiver in no less than 300 words, by the way. I know 20 or 30 was talked about.
Yeah, that
I could
that would take
at least that long,
forever.
Judge.
The fact that you said that, I realize I'm very blessed by the people doing it. Go ahead. So what do you want me to do?
So if I could just come in a bit later that day, I'm sure I could be here by 10:30.
We'll wait with bells.
Thank you so much, Your Honor. I appreciate you.
Court does call the case. People versus Kadera Akiji. 3 cases.
You want to do it down here?
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on the case ending in 1678.
Assistant Public Defender Natalie Pate on behalf of Mr. Akiji on the other 2 cases, the ones ending in 5790 and 5801. Mr. Akiji, can you state your name for the court, please?
I think he was saying it.
Thank you, sir.
What are we doing?
Your Honor, we're here. We've requested a competency evaluation and also criminal responsibility evaluation. I also sent over some supplemental materials there.
And I do have the same request for both of my files, Your Honor.
Okay, I have did you submit? They're in there, because they're just not marked. Okay. So what I will do is I will sign that for the forensic evaluations. Set competency hearing in this matter for March 26, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
By Mr. Catchy.
Court calls case of the people versus William Riddle.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Riddle, who approaches the podium.
Your name, sir?
William Michael Riddle.
All right, what are we doing?
We had set this day to make sure that I had all the discovery. I've spoken with Ms. Zenda at great length. I have all the discovery, and I believe we have an exam set for next week, Your Honor. We're good to go.
And Your Honor, this was the case where we originally thought we had discovered before. We were up last week and the court indicated they would set it on the 30th.
Right, I had not said it yet, but I would set it on the 30th. Okay.
My apologies, Your Honor. I thought it was already set. I had such faith in Ms. Zenda's office.
Preliminary examination in person will be set for December 30th, 2025, 12 noon. And that is before me.
Thank you, Your Honor.
Thank you. Calls case People versus Amber Almany.
Water Assistant Prosecuting Attorney to the people.
And Assistant Public Defender Natalie Pate stepping in for Mr. Gaddy on behalf of Ms. Almy, who stands to my right. Please state your name.
Amber Almany, Your Honor.
Thank you.
Thank you, Your Honor. I do have a green sheet prepared by Mr. Gaddy, Your Honor. We are requesting an adjournment for mitigation purposes.
Without objection, probable cause conference will be adjourned to January 15th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, ma'am. Court calls case of the People versus Moses Cunningham Page.
Water Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Assistant Public Defender Alexis Serpswithan on behalf of Mr. Cunningham Page.
Your name, sir?
Moses Cunningham Page.
Thank you.
Your Honor, he is executing a exam waiver. Right. And Your Honor, with that,
Sir. Go ahead.
I did submit an order for release to inpatient treatment that was going to be a part of the agreement between defense and the prosecution for an order that may be available to him in circuit court.
People had no objection to that order.
No, Your Honor.
But he does need, yeah, you're gonna need a tether proprietary place. All right. So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
All right. People also waive their right?
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
We acknowledge receipt of the complaint, waive the formal reading and stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
January 6th at 1:30 before Judge Company.
January 6, 2026, 1:30 before Judge Company. Bond will continue.
Thank you, Your Honor.
All right, thank you.
All right, let's change it up again. Let's go back to DeKalb County and Mike Jacobs. It looks like he's starting to work with people in Orange now.
As well, that doesn't show as having a case number on Odyssey. I'm just going to request a bond, a reduced bond for all three of them together. But for some context, Judge, she has been held for 7 days. These are three separate shoplifting cases. She has a $1,000 bond on each of them. My request to Your Honor would be that Your Honor reduces her bond to $1,000 inclusive of all three cases. with regard to Miss Collins' biographical information. She's 63 years old. She lives with her niece in Fulton County. She's been here her whole life. All of her ties are here. She has a son who she cares for, who recently sustained injuries in a bad accident. She is currently unemployed and looking for a job. She has work history doing hair and has a bunch of practice hours in cosmetology. She also is diabetic and needs daily medication. I understand, this is 3 separate shoplifting cases. I would request that Your Honor reduce her bond to $1,000 for all of them. $3,000 is just, she's not going to be able to post that. She's not, obviously there's no allegations of violence here, that she's a threat to anybody. So I would just request that Your Honor reduce her bond.
Mr. Weldon?
Yes, Your Honor. The state has a number of concerns with reduction here. In addition to, I guess, the now 2 other pending DeKalb County shoplifting charges, she also has another pending shoplifting charge in the Metro Atlanta area. And this defendant has at least 13 convictions on her record going all the way back to the early 80s. Consistently in each decade since the 80s, this defendant has picked up charges. And one of those, at least one of those being a felony. So given the 3 other pending shopliftings in Metro Atlanta, the defendant has shown a clear disregard for following the rules of the law of the state of Georgia, and the state would just request a bond citizen.
Well, I mean, we're still asking to keep a $1,000 bond in place. So, I think that's fair under the circumstances. So I'm going to, I'll tell you what, I will convert 2 of the 3 cases to a UJR. And one of them whatever the most recent cases needs to have no change. Whatever the most recent cases needs to have no change. But the earlier 2 cases can be UJR. Don't violate the laws of any governmental unit or entity. Stay away from all incident locations. So all 3 of them need to be in each bond order. All 3 locations need to be in each UJR order. So the locations for all 3 cases. Stay away from those 3 locations. And unless are they like all Walmart cases or no? Like one store? Ms. King, you're muted.
Oh, sorry. Okay, I'm looking right now.
Looks like CVS.
All right, well, never mind then. So we're gonna do let's do yes, that one defendant is good to go at the juvenile detention center. That you're all set. And then but not the Sumter County defendant. And then yeah, all right. So all 3 incident locations in the 2 UJR orders. So UJR, don't violate the laws of any governmental unit or entity. Stay away from all 3 incident locations. Return to court on a future date that I will set, and we will leave one of those $1,000 bonds in place.
And I think it's the same CVS, Judge, by the way.
Oh,
so
well,
it should
fine.
just be
Well,
one.
stay away from the CVS.
Yeah, gotcha.
Alicia Dixon, 2 cases.
So Judge, she's actually only being held on a case that's not on the calendar that the state has consented to a UJR on. So I will be preparing that order for Your Honor. And
Okay, that's fine. Let's move on. Consent UJR,
Okay.
right, Mr.
Gotcha.
Weldon?
Yes, state consent.
All right. Thomas Gask.
For Mr. Gaskew, Judge, this will be a bond hearing. It's my understanding, I thought Your Honor would be in the courtroom, but Mr. Weldon informed me that there may be some individuals who are here in support of him. I believe family members. As far as biographical information, Judge, well, Mr. Gaskew has been held for 7 days on no bond. I believe he was denied bond at first appearance because he is currently on either probation or parole for a charge that he, I believe, paroled out, and Mr. Weldon will correct me if I'm wrong, paroled out in 2022.
You don't need to stand around. I'm not here. We're not going to be able to do that today. So just leave it on Mr. Weldon. I mean, family members don't necessarily have a right to address the court.
Understood, Judge. I just
we're not
wanted to
gonna
let
be
you
able
know.
to handle it today.
Okay.
So,
Circling back, Judge, yes. So he was denied bond because he's currently on probation or parole. He is 33 years old. He has a stable address in Lithonia where he's lived with family for years. No objection to a no contact with the alleged victim. They don't live together. He is from Georgia. His family is in Georgia. Obviously, he has significant family support since they came all the way out in person for this court hearing. He has, I believe, a child on the way. He has a high school diploma as well as a certification for business administration. He has a stable job loading and unloading delivery trucks and stocking shelves for a brand distribution business. He will return to that. We're just requesting, Judge, I understand that he was initially denied bond, but it's my understanding that that was just because he is currently on probation or parole, and that will be handled. I'm sure he may be violated for that, but I would request that Your Honor set a low bond for him, like a $2,000 bond. And again, we would have no objection to a no contact with the alleged victim.
Mr. Weldon.
Yes, Your Honor. Judge Thompson, did deny bond on the 18th, last Thursday, under 1710-1 OCGA 1710-1. This 33-year-old defendant has quite the history, the criminal history, including a very serious armed robbery conviction in 2013 in Cherokee County. The conviction was armed robbery, the hijacking of a vehicle, possession of a firearm, and the commission of a felony. In Cherokee County, the defendant received 20 to 12 on those charges, 20 to 12. The defendant was released in 2022, and so my understanding is he would still be on parole, so parole is eventually going to find out about this. But the fact that he goes and commits a violent crime against the mother of his child 3 years after being released from very serious charges in prison gives the state some very serious concern. And the facts of this case, the state would prove at trial that the defendant attacked Miss Elena Diaz, the mother of his child. He slammed her to the floor and kicked her in the face. So given the seriousness of these charges and the extensive criminal history, including serious felonies, including armed robbery and hijacking, the state believes no change in bond condition, or no bond whatsoever being appropriate in this case. And yes, Your Honor, the mother of the defendant is here in court for the court's consideration.
All right. Well, that's not going to happen today. So, under the circumstances, I'm not going to order a change in bond at this time. I will order a 2-week bring back,
So Judge, no bond at all?
I mean,
would you consider setting a high bond? I understand the state's position, but
that's fair. I will tell you, with this history and the allegations in the case, it's not even going to be one of the I'm not even willing to put it on par with one of the high bonds that I might issue on a bench warrant, which
understood, Your Honor,
happens on occasion, almost rare occasion, but certainly on occasion. I will grant a $20,000 cash or surety bond. $20,000.
Understood, Judge. With a no contact.
No contact.
And no violation of any laws of the state of Georgia, Your Honor.
Yes, right, absolutely. And I do know that we need to interact with the magistrate court about that. Not my court, but we do need to talk with them about that. But 20 per the discussion in open court last week. But yeah, $20,000 cash or surety. Don't violate the laws of any governmental unit or entity. Stay away. A bond is appropriate under the circumstances, but I do think it needs to be a high bond and higher than I ordinarily give in the courtroom. So so it's going to be under any set of circumstances. So so $20,000 cash or surety. Don't violate the laws of any governmental unit or entity. Return to court on a future date that I will set, and stay away from the alleged victim.
Understood, Judge.
All right. Next, we've got Jordan Gatt.
So I want to cut in here a second and comment. So this is a new judge for us. It's not one that we've watched live before, so it's hard to pass a whole lot of judgment. In the same respect, it definitely seems like he's trying to hurry through his docket today, denying the ability of family members to be heard and whatnot. But what got me was he said that's not happening this time or right now, words to that effect, implying that he will let family members speak at other times during his court sessions. So that strikes me as an inconsistency of justice. Now, let me know in the comments what you think, but based on what I'm hearing, and if my assumptions are right, then I have a problem with that. The idea that just because he's in a hurry, because it's coming up on a holiday, that his court should operate differently from what it normally does. That's my impression. I could be wrong, but let me know what you think.
I recall the prior bench warrant. I'm just going to note that, but at this point, I'll do it. Let's not have this happen again. February 25th, arraignment at 1:30 p.m. February 25th, arraignment at 1:30 p.m. And then I've got Matthew Johnson.
I think he's also was produced, Judge. So can we get the same bring back date as Mr. Bailey?
Sure. What was that? 3 weeks?
3 weeks, Judge.
All right. Matthew Johnson, that's going to be a 3-week bring back, 3-week bring back. And the public defender is going to talk with him in the interim. Brandy, and that's the Sumter County defendant?
Yes. Yes.
Okay. Yeah, he can be released. 3-week bring back there. Brandy Joseph?
UJR.
Consent UJR?
Yep, consent UJR.
Okay.
Yes, Your Honor.
And then we've got, sorry, and that's 2 cases. Andre Lucas?
Consent UJR.
Yes, Your Honor.
All right. Mayasir Mini, 2 cases.
Out of custody.
Okay. Crisanta Perez.
Out of custody.
Diamond Robinson, 1, 2, 3 cases.
These are the last bond hearings, Judge.
Go ahead.
And the victim is also here, just so you know, Your Honor. I believe he wishes to address the court. Would you like me to make my argument first?
Yes, please. And it's all going to have to be brief, everyone.
Understood. Judge, to keep it very brief, Ms. Robinson's been in for 13 days now. She has a $25,000 bond on a battery, family violence, criminal trespass, and then she has a $1,500 bond on a case she had previously bonded out on, but her mom came off of that bond, so she's being held on that as well. Judge, Ms. Robinson is 27 years old. She is less than 1 month postpartum with a preeclampsia diagnosis. The jail medical team went so far as to call Grady to confirm her current medical situation. She's struggling significantly. The alleged victim is on the call here. He does want to make a statement. She does have 3 children, 1 311, and then the 2.5-week-old baby boy. She has an address in Stone Mountain, been in Georgia her whole life. She does have 3 pending battery family violences, inclusive of this case, against the same victim. I would note, Judge, I think this is relevant, a little difficult, obviously, because he's on the call, but he does have an open aggravated assault, sexual battery against her, as well as an open stalking case against her. So obviously this is not a good situation all around, but I do believe that he would like her to get a bond and to get out of custody, and has significant concerns for her being in custody, especially with such a high bond. So, Judge, I would request that Your Honor reduce her $25,000 bond to a $1,000 bond, and reduce the other older case where they came off of the bond to just a $1,000 bond as well. Would you like to hear from the state or from Mr. Robinson, the alleged victim?
From the state.
Thank you, Your Honor. I'll be pretty quick about this. The defendant has some criminal history, given the fact these are battery cases. Her 2017 battery conviction is relevant, as is her 2019 disorderly conduct and simple assault family violence conviction. And those convictions are in addition to the 3 pending battery family violence charges she has right now against the same victim, Mr. Ontario Robinson. It's concerning to the state that the defendant gets out and then reoffends again. And then the criminal history for Mr. Robinson that the state's unaware of, but that the public defender is in property of court, suggests that there is difficulties between these two that are a classic case that they just shouldn't be around each other. Unfortunately, a no contact bond has been violated in the past. The state fears more violence will occur, especially with Ms. Robinson's history. The $25,000 bond, if Your Honor decides to reduce that, certainly not 1,000. I mean, maybe something like 5 or 10, but Judge, the cycle of violence and domestic violence, these repeats, I fear that if this defendant gets out, we'll just see her again in 3 weeks on another jail calendar.
All right, and let me hear from the, so who's the alleged victim here?
Ontario Robinson, Mr. Richardson. I'm sorry.
Come on the screen, Mr. Richardson. You've got about 15 seconds to do that. Raise your right hand. Do you swear affirm and unmute? Unmute. Do you swear
Yes.
affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Go ahead.
Mr.
Honest,
Go ahead,
yes,
Mr. Richardson.
yes, the allegations aren't really true. She shouldn't be there in the first place, and obviously life is hard. She shouldn't be there. She didn't do anything. And like stated, it is 3 small children that she is needed for, and also concerned for her health. So her family, the community, it really, we're willing to help her out. Anything, no contact should never be involved or included in anything, with the judges, with your respect, sir.
So, Mr. Weldon, so wait a minute. What are the current bonds again?
Judge, the newest case is $25,000, and then the older
They're
case is
very high.
$1,500.
The other case is what?
$1,500 bond, Judge.
$10,000 bond at position number 29 in this game, but I could have misread that. I saw a $25,000 bond in position number 30, and I saw a $10,000 bond in position number 29.
If I can state that I'm not a victim at all. I'm not
All
a
right.
victim, like I said.
Well, I'm at, okay. Let me just make sure. So we have $1,000. No, wait, one's an accused
So,
case.
Judge, right now she's being held on 2 cases. She does have a third. I believe that might be the one Mr. Weldon is referring to.
But that you're not asking for anything.
No.
Nick.
No.
Right?
The only thing I'm asking, yes, you're correct. The only thing I'm asking for is in case 25S008026, where she has a $25,000 bond, for that to be reduced, as well as case 25S, 25S008100. Okay, the booking number is different, but it's 25S008110, where she has a $1,500 bond. I'm looking at Odyssey right now, so that's what I'm seeing. I'm requesting that your judge reduce both of the bonds to $1,000. That would be a $2,000 inclusive bond. that would get her out of custody.
And she has another case with a $5,000 bond?
She has another case. I'm not looking at it now, Judge, but I do believe she's out on bond for it currently, and I don't know what the bond amount was.
Well, I'm not going to reduce the one that's at $1,500.
Right. Understood, Judge.
Sounds like she made a $5,000 bond in another case. What sounds to me to be appropriate here is in the case with the $25,000 bond, I'll reduce that to a $10,000 cash surety bond. Don't violate the laws of any governmental unit or entity. Stay away from the alleged victim and return to court on a future date that I will set. So $10,000 cash or surety. Don't violate the laws of any governmental unit or entity. Return to court on a future date that I will set, and stay away from the alleged victim. And that's in the case with the $25,000 bond. I'll reduce it to 10, and that's as far as this goes. Okay.
Okay.
Ms. King,
Yes.
she wants to tell you.
No, I just wanted to ask.
Don't tell me anything on Zoom. when the
No.
prosecutor's
We
sitting
need,
right there.
so this is not just talk to your lawyer in open court, across Zoom. She'll call you. She'll call you.
I'll call you, Miss Robinson. Just don't talk to me on a recorded Zoom call.
No. I asked her first, Judge. She wants you to repeat the bond. That's all.
Oh, the bond amount.
The bottom line is the one case that's $25,000. That one case is being reduced to 10. The one case that's $25,000. She also has apparently a $5,000 bond that she made.
Yes.
And a $1,500 bond that's remaining in place.
Yes.
All right. Neo case.
UJR, Your Honor, consent.
Okay, then I've got DeMonte Stewart.
Out of custody, Judge.
Darian Surrey.
Sent updated contact information, would request, Your Honor, lift this FTA. It looks to be from arraignment 6/30/25.
All right, we'll set this one for February 25th arraignment at 1:30 p.m. February 25th arraignment at 1:30 p.m. Courtroom 3C of the DeKalb County Courthouse. Amend Tate.
Judge, I really added this one for status. He's not going to make any bond, so it's currently unaccused. I would just, however soon Your Honor wants to bring him back. I don't want to give Your Honor a number, whether that's 2 weeks, 4 weeks. I just want to make sure that hopefully it gets accused sometime soon. So
well, when are you gonna? Okay, but when are you ready? You're ready in 2 weeks or 3? I was a little confused about that.
I am on his case, Judge. This is just I want the case accused. It's not like I have. There's any.
You needed time to talk with the 2 defendants who are in prison, correct?
Yeah, those exactly. That's separate. This Mr. Tate, he's in custody. He's been in custody for a significant amount of time at this point. I just want the case accused so that we can move forward with it.
Okay, we can do a 2-week bring back on this one. 2-week bring
Gotcha.
back. Joshua Wiggins.
Requesting 2-week bring back, Judge.
All right. And then Caleb Williams died, 2 cases.
So I sent along updated contact information. There is a new criminal trespass warrant that is not on the calendar that the state has consented to a UJR on. So I will be sending a bond order for that one, Judge, but I would request that you lift these 2 FTAs.
That's fine. We're going to set these for both cases. I know one was previously on calendar call, but they need to track together. So we're going to do both cases, February 25th arraignment at 1:30, February 25th arraignment, 1:30 p.m.
Okay, Ms. King, I just have one question.
Not on recorded line. I'll call you.
Okay, well, did they consent it to a UJR?
Yes.
Okay.
Yes.
All right.
Yep.
Thank you.
Yeah. Okay, so February 25th arraignment, 1:30 p.m. We're going to recall these 2 bench warrants. Even though one case was a calendar call case, it needs to go back to arraignment so that it can track with the second case. All right, that concludes it. We have a defendant who apparently was kicked off.
Okay, well, that court's transitioning into other things now, and it's getting to be about that time anyway, so I think we'll call it a day. But as we were discussing in the chat here, I'm very confused by this guy. First time we've really gone to him on the live show. I've watched him a couple times prior, so just like off stream. So my impression is that the brand of justice he was giving today is not his norm, but I do want more data. So after the first of the year, we're going to try to go back to this court a couple of other times and see how it matches up. Programming note for the next 3 days, we will do a best of show in this time slot. We won't be live because there won't be much live court except maybe some bond courts here or there, some first appearance kind of stuff. But we will do best of, so we will still have content for you that will go live at 10 a.m. Eastern, 7 a.m. Pacific as always. But we should be back live next Monday because courts should be up and running at least for the first couple of days of next week as well. So we'll check that out. I want you to go all have a Merry Christmas. Enjoy time with your family. Eat some good food. If you are religious like myself, remember the entire reason of Christmas because I think that's important. But at the very least, just be kind to each other and enjoy your family and take it easy for a little bit and maybe stop in and see TCF from time to time. But I care for all of you. Thank you so much for spending time with me today. Go have yourselves a good holiday, and we'll see you soon. Take care. God bless.